So my name is Howard Penn. I'm the Executive Director of Planning and Conservation League. Welcome to our second annual virtual California Assembly. We've held this assembly for many decades in person in Sacramento, and our last year and this year doing it virtually. So welcome. We're excited about this upcoming session today. We have some amazing panels coming up in the next couple of weeks. We are focused this year on the climate crisis is here now. And we have two sessions a day, the two today, starting this morning, and then another one later this morning, over the next 4 Thursdays. So the next 4 Thursdays, we have these sessions. You can find our schedule at pcl.org/assembly. And hope that you will be able to attend or can attend some of those other sessions. Your registration allows you attendance to all 4 days and any of the sessions. For those that haven't joined us before, each day there's 2 sessions, one starting at 9, one at 10:45. You can use the same Zoom link. So if you stay on this Zoom link through both sessions, you can just leave it open. You can also log out and log back in if you want using the same Zoom link. And you can attend as many as you want over the month. There'll be a 15-minute break between each session. And so, like I said, you can put it on pause or you can log in and log back out, whichever works best for you. So some helpful information about our sessions that we'll be doing today. There is a Q&A period at the end of each session. So if you'd like to participate, please enter your questions in the Q&A feature. We'd like to reserve the chat box for comments and keep all the questions in the Q&A. So if you have chat that you want to put out, suggestions, thoughts, put that out in the chat. But if you have specific questions for the panelists or the moderator, please put that in the Q&A box. We like to have both options so that people can communicate via chat with the entire group and audience, and Q&A just for the questions. These sessions are being recorded, and a link to these sessions and the presented material will be emailed to you soon after the session, or you can find them at pcl.org registrant info. I'll have Sophia put these links in the chat box as well, so you have those there. There will be a feedback form once you leave this session. Please fill those out to let us know your thoughts. They're extremely helpful for us to plan for future assemblies. And especially since last year and this year we're new to this virtual format, we like any input you have. If you have any questions, you can contact us at events@pcl.org. And if you'd like to support PCL's assembly and our work in general, please consider donating at pcl.org/donate. We depend on our donors for all the work that we do. I want to give a big thank you to all our sponsors. We couldn't do this without you, and want to really give a special thank you to our gold and silver sponsors, Ralph Perry, Chatton Brown, Carson's and Minter, Sage Sweetwood, Vistra, Shoot Mahaly and Weinberg, and LADWP. So thank you so much for your support. It's what allows us to do these assemblies. Okay, let's get started on our first session this morning, updating California water laws in the face of droughts and climate change. And I have the great pleasure of introducing the moderator, PCL's Senior Water Policy Advisor, Jonas Minton. Take it away, Jonas. Thanks.
Good morning, everybody. A little over a year ago, PCL convened some of the state's leading water law and policy experts to look at California water rights. This was 4 decades after the last comprehensive review carried out by the Governor's Commission to review California water rights law. As you can see from the list of participants, this is a very experienced and knowledgeable group. Because some of you are calling in and not looking on the screen, I'm going to read off their names so that you can hear them. Clifford Lee, former Deputy Attorney General of the California Department of Justice. Jennifer Harder, Professor of Law at McGeorge School of Law. Rick Frank, Professor of Environmental Practice at UC Davis School of Law and former Chief Deputy Attorney General of the California Department of Justice. Barton, known to most of us as Buzz Thompson, Professor of Law at Stanford. Tam Doduck, former board member, State Water Resource Control Board. Ali Dorimas, Professor of Law, UC Berkeley. And Camille Penu, former Director of Water Justice Clinic, UC Davis, and visiting Assistant Clinical Professor of Law at UC Irvine School of Law. Now, their work started off, I'll tell you candidly, as an academic exercise. No one thought that their recommendations would have any realistic chance of being enacted or frankly even listened to. But then the skies dried up and even the April meager snowpack suddenly disappeared. All of a sudden, their work became much more relevant. I have to note this, PCL's role was strictly limited to bring these experts together and providing them logistical support. PCL had absolutely no vote on the recommendations they developed. These are their unanimous recommendations, not PCL's. Now, the link to the full report has just now been put in chat. It has also been posted today on the PCL website. But we really don't want you to be speed reading 43 pages while the panelists are giving their presentations. So here is a summary of the 11 recommendations. Again, because some of you are calling in, I'm going to read them quickly. In the area of implementing the human right to water, it's explore funding sources for NGO and tribal participation in state board and regional board proceedings. This is modeled after what's done at the California Public Utilities Commission. Require at least one member of the state board and the regional boards to be qualified in the field of water supply or water quality related to environmental justice. Implementing the Human Right to Water Act adopted in 2012 by imposing a duty on groundwater sustainability agencies to mitigate for adverse effects due to groundwater extraction on domestic wells. In the area of updating water rights administration to address drought and climate change, there are recommendations to revise the statutory adjudication proceeding, giving the state board the authority to initiate adjudications and include interrelated groundwater. Improving service water rights verification. This would be for board-initiated verification proceedings, where the burden of proof would be on the claimant, and there'd be some reforms on the forfeiture procedures. Interim relief authority, and you'll hear more about that, so that the state board can provide relief when it is urgently needed, protecting all rights of the water rights holders. Real-time monitoring of diversions and use with some pilot projects. And then requiring the state board to adopt regulations to set up practices and methods for determining whether water is available in water rights proceedings that address the effects of climate change on the anticipated watershed hydrology. Then as we move down to addressing the extinction crisis facing California's native fisheries. One recommendation is to include actual deadlines for completion of the Sacramento River Delta Plan update and implementation of the San Joaquin River and South Delta Plan updates. This is colloquially known as updating the Bay Delta Water Quality Control Plan. And the second one is to amend an existing provision within the Fish and Game Code to require that water temperature be a factor in what the volume and temperature of water released from dams needs to be. So as you can see, the group addressed the three areas of implementing the human right to water, updating water rights administration to address drought and climate change, and addressing the extinction crisis facing California's native fisheries. We have two of the authors here that are going to be addressing a selected number, not necessarily the most important, but some of the recommendations. And then we will have a response by one of the key legislative staffers. Now, Clifford Lee, as I briefly described, was Deputy AG representing the State Water Board and DWR and other state agencies for actually over 40 years until he recently retired. Jennifer Harder, professor of law at McGeorge, she's a co-author of the water law textbooks, Cases and Materials on Water Law. That's a 10th edition. So if you only have the 9th, you should go out and buy this one for her. Her research focuses on integration of classic water rights principles into contemporary regulatory systems, water and growth, and issues of water justice. And as I said, then we'll get a response from Dennis O'Connor. Dennis is chief consultant to the California State Senate Committee on Natural Resources and Water. He's been a major player in all sorts of things, including the 2007 package of flood legislation, the 2009 water package, the Sustainable Groundwater Management Act, SGMA, and most recently, Making Conservation a California Way of Life. He's been with the Senate since January of 2003, and I worked with him on water even before that. So we're going to ask you again to write your questions and answers in the Q&A function. And with that, let me turn it over to Jennifer.
Thank you, Jonas, and thank you to Howard and all of the Planning and Conservation League for your support of this process. It's my honor to be here today and was my distinct honor to be part of this remarkable group of water experts. I'm going to talk about one of our pillars of our 3 recommendations. First, water justice. I'll turn it over to Cliff, who will weigh in, and then I will come back in before we go back to Dennis. One of our group's top priorities for our recommendations was to address the continuing water crisis in California's disadvantaged communities. We know that the sad fact is that 1 million Californians do not have safe drinking water. And one of the scenarios that lead to this failure of safe drinking water is where the residents rely on their own wells at their own homes for that drinking water instead of depending on a municipal supply, and these are known as domestic wells. During the last drought, about 3,500 of these domestic wells went dry. So I'm going to talk a little bit about the basics framework for this situation in order to provide context to the recommendation. I know some of you know this background already, but many of you may not. Now, many of these failing domestic wells are located in economically disadvantaged communities. Many of these communities are historically underserved minority populations that have been subject to explicit and implicit racism in the delivery of services, including water. Now, the supply crisis in these communities is heightened by water quality crises, contamination from agriculture and industry, and other issues. In the last 10 years, as Jonas mentioned, the state has taken action to address this crisis, including passage of the Human Right to Water Act in 2012, which is part of the Water Code. This act provides that every Californian has a right to safe, reliable, affordable water. The state has followed the Human Right to Water Act with other measures, such as funding to support improved water service to disadvantaged communities, policies in our state regulatory agencies, and others. And these steps have been a very good start. Our group very much supported these steps, but we believed that much more was needed to address this crisis. And so we have focused on 3 reforms with the understanding that additional steps should be taken. And first, the group recommended that 1 member of the State Water Resources Control Board and Regional Board be identified as an expert on the issue of environmental justice, and specifically the issue of water for disadvantaged communities. This parallels some of the ways in which the board members are already structured with identified expertise, adds this new expertise. Second, the group recommends that the state water board and the regional boards explore funding sources for environmental, NGO, and tribal participation in agency proceedings, with the suggestion that the boards explore the model used at the California Public Utility Commission for intervenor compensation, knowing that adjustments would need to be made to be responsive to the board context. And third, and this is where I want to focus my time, we recommended that the state affirmatively implement the human right to water law by requiring agencies that manage groundwater to mitigate for adverse impacts on domestic wells. So as a little bit of background, we know that in 2014, California enacted major groundwater reform with the Sustainable Groundwater Management Act, or SGMA. This law addresses chronic overpumping of key groundwater basins in the state and requires formation of local agencies called groundwater sustainability agencies. These agencies are required to adopt plans, groundwater sustainability plans, and within 20 years of adoption to achieve sustainability in those basins. They also have to make interim progress toward this goal. Now, the plans have been due in 2020 and very recently in 2022. And the Department of Water Resources has been reviewing those plans, has released some assessments, and has found in many of the instances that the plans need more work on drinking water issues and domestic wells. So this in part supports the direction we have gone with this recommendation. Our group believed very firmly that California water law should include standards that expressly and unambiguously protect disadvantaged and historically underserved communities, correcting the systemic inequities in those communities. So the recommendation goes like this. Specifically, the groundwater agencies would be required to do 3 things as they plan to achieve sustainability. First, to expressly determine whether groundwater extractions impact domestic wells. Second, to mitigate those impacts by, for example, repairing or deepening wells or facilitating connection to reliable water sources. And third, to ensure that mitigation does not impose unreasonable financial burdens on domestic wells. This may require compensation for costs, increased energy costs, alternative supplies, etc. So the group believed that achieving groundwater sustainability is a necessary and commendable goal, but we also believed that the state must not place the burden of achieving that goal on its most vulnerable individuals and communities. So with that, I will turn the mic over to my colleague, Cliff Lee, and I'll talk to you again in a few minutes.
Thank you, Jennifer. I too would like to thank PCL for hosting this group of water specialists. This is an important project, which I am glad to see we've been able to reach some conclusion on. Now, I've been asked to talk about the second general category in which the group worked upon, and that is updating water rights administration to address drought and climate change. We have 5 recommendations. I'm only going to focus on 3 of them for the moment. One, incorporating climate change into the water right permitting process. 2, providing for first steps for real-time monitoring reporting of water right diversions and use. And 3, the improvement in the surface water rights verification of so-called pre-1914 water rights. Let me just jump ahead here with regard to issue and reform number 1, incorporating climate change into the water rights permitting process. A little bit of background. I know many people on this call are going to know this stuff, but many may not. Ever since the adoption of the Water Commission Act of 1913, the State Water Board or its predecessor has been required to determine before it issues water right permits for the diversion and use of surface water that there is, quote, unappropriated water in the watershed in which the water project is to be developed upon. under the existing statute, this is done, generally speaking, this way. The water board makes the determination of what the unimpaired flow is within the watershed. The water board then makes a determination as to who are the senior water right users already in the system who are diverting and using water. And then the water board makes a determination of how much water must be left in the stream for public interest values such as fish and wildlife or salinity control. And then the water board takes the latter two factors, subtracts them from the first factor, the amount of unimpaired flow, and determines if there's any surplus. Roughly speaking, and I'm sure any hydrologist that is in this call will understand the details that I've left out. This is how unappropriated water is determined. And this is particularly important because if you're going to develop a new water storage project within a watershed, there's got to be water that's unappropriated for your project. Now, remarkably, notwithstanding the fact that this requirement of determining whether there is unappropriated water in a stream before a new water storage project can be built, neither the water code nor the state board regulations provide any guidance as to the methods to be used to determine whether there's unappropriated water. The historical practice has been that the water board and the water right applicant have relied on what I'm going to call backward-looking historical water measurements within the watershed. Mostly information from water gauges or from extrapolated from that data. All right, and they have used that to estimate how much unimpaired stream flow there is in the stream. Typically, a water project may look at a 43-year historical cycle and say, well, what's the average out of those 43 years? Now, one of the things that we know that's absolutely true is that past reliance upon backward-looking flow estimates based upon historical data to determine watershed stream flow is no longer defensible given climate change. We just simply know that. Climate change will result in less precipitation as snow, shift peak runoff from historical patterns to earlier portions of the year, shorten the precipitation season, and increase the intensity and frequency of drought. There simply will be less water in the future. All right. Not to make light of this, but my view is to rely now on historical data to determine future flow requirements, flow estimates in a watershed is to embrace what I'm going to call the waiting for Godot fallacy. Now, as you all know from the Samuel Beckett play, Godot never arrives, all right? And that is the problem with using historical data to determine future flow. The flow is not going to arrive. Understanding this principle, the water group that I've had a chance to work with has as its a recommendation that the water board, for the first time, develop and prepare regulations that set forth the methods and practices for determining unappropriated water, something it has never done, and to include within that the requirement that any water availability analysis be based on climate change developed models that anticipate what future flows will be in the watershed given the effects of climate change, and not to rely exclusively on historical data. I think what we will likely see when those regulations are developed and best available science is applied to determine water availability, that we will have certainly less flow within a stream system than what the historical data would provide. This is, I think, an important way to incorporate climate change into the water right permitting process. It could also be used in managing existing water rights that have already been issued. So that's the first recommendation. The second recommendation in this category that I want to talk about is real-time monitoring of diversion and use of water. Astoundingly, in California, the land of high technology, the state of California lacks the ability on a real-time basis to determine who is diverting water from surface water sources, when such diversions are occurring, and in what amounts. This deficiency hampers the state's ability to manage surface water, particularly in time of droughts. Generally, except for riparian water rights, where, as those water lawyers out there will know, shortages are allocated through a sharing process. The rule of appropriate rights is that senior diverters have the priority to divert over junior diverters. Now, if senior diverters take more water than their allocated share of water, or take water outside of their authorized season of diversion, the resulting reduction in flow may force junior diverters to reduce their diversions earlier than the priority rule would require, and may reduce flow for fish and wildlife and other public interest usage. So it's extremely important to get a handle on a real-time basis during drought, who's taking how much water, when they're taking it, and where they're placing it to beneficial use. All right. Under existing law, the only mandates that surface water diverters report their diversion use data annually, and only for the prior year. So basically, during the drought, the state is flying blind. We do not know who's taking water. And this therefore suggests that we should move where possible to a real-time management process. Now, the group we've been working with has developed what I think is a prudent approach to this, which is to require that the State Water Board set up a pilot project in at least 2 watersheds to determine whether we can require surface water diverters in use, and under what technologies and under what methods, to provide real-time reporting on diversion and use of water, and that the board would then develop the information from these test projects in these watersheds and prepare a report as to what extent we could expand that. Now, one might say, well, if it's important to do real-time reporting, why don't we immediately apply it throughout the entire state? All right, and I think that probably, and certainly the group's judgment was, maybe we're not quite there yet. All right, that it would be valuable in this area where we have never had real-time reporting before, to do test projects first. All right, see what works and what doesn't work, and then in fact move ahead based on that information to go forward with maybe a broader project. And this assignment would be given to the State Water Board with the necessary funding to complete it. What is that old Spanish proverb? To talk about bulls is not to be the same thing as being in the bull ring. All right. A lot of people say, well, let's go ahead and move to real-time reporting now. Well, that's, at this point, I think, just talk. Let's get into the bull ring. All right. And let's see what works and what doesn't work. All right. And then move from there. The third recommendation that we've been working on has to do with improving surface water rights verification. As I think most of you know, California has this patchwork system of surface water rights that is unlike any other system in the Western states. We have English common law riparian rights. We have mining custom pre-1914 appropriative rights. And then we have a statutory system which was adopted in 1913 and effective in 1914, which requires you to get a permanent license in order to appropriate water from the State Water Resources Control Board. We are fairly unique in that in the Western states. I might add, by way of comparison, that Oregon has long since recognized that their pre-code water rights must be melded into their permit and certificate system. In the state of Washington, Washington simply by statute abolished unused riparian water rights, and that the abolition of unused riparian water rights by the state of Washington was upheld by the Washington Supreme Court. In Colorado, they never recognized riparian water rights, and they just simply have an appropriative water rights system. Now, however, in California, we have had this system of a patchwork of what types of water rights, which has left considerable confusion. Because since these pre-1914 rights, riparian and appropriative, are not rights to which the Water Board issues permits and licenses, their scope is unclear. So the group we have been working with has recommended that the board be granted the authority to conduct investigations to determine the verification of these water rights and to see whether they in fact have a legal basis in law. Now, in many of the other Western states, this issue is addressed with by stream adjudications, where the entire stream system is adjudicated by a state agency. That certainly is the case in Oregon. Now, the problem with that is stream adjudications seem to work on small streams, but don't seem to work in any practical fashion on large streams. I suggest as an example, I would note the state of Oregon started a stream adjudication effort on the Klamath River in 1976, and it's still not complete. So while adjudications have importance, and one of our recommendations goes to that, they cannot be an effective real-time water management tool. So this recommendation gives the board the authority not on an entire stream system, but as to individual diverters to conduct investigations and to determine whether an individual diverter actually is diverting on a legitimate basis of right. And in doing so, bring more unity and clarification into our water rights system. I would like to say that this recommendation brings California into the 21st century on water resource management, but actually, in comparison to the other Western states, it really just brings California into the 20th century. We have asked that we move forward on something that most of the other Western states have already adopted and update our laws to better reflect a more unified water rights system. There are two other recommendations which I don't want to really spend any time on now in this category. One, we would recommend that the board be given the power to initiate statutory adjudications, which it doesn't have now. A power, for example, that the state of Oregon Water Resources Department has had for many years. And we also recommend that the board be given the authority to issue interim relief orders when it conducts a water right enforcement proceeding. But I will leave that discussion to the Q&A. I think, Jonas, I think that's all I have for the moment.
Thank you, Cliff. And I'm gonna jump in and go over our final set of reforms that we'll talk about this morning until the Q&A at least. And these reforms will address the extinction crisis facing California's fisheries. So in this regard, our group focused on the fact that California's fish populations are clearly in crisis. And just as an example of the many statistics and data out there of California's 125 plus native fish populations, 7 species are already extinct and 100 are in decline. To address this crisis, our group prioritized 2 recommendations that we thought would have high value for the state's fish populations, again, understanding that many other approaches could and probably should be taken. So our first reform is the recommendation for legislative adoption of deadlines for completion and implementation of the Bay Delta Water Quality Control Plan. Again, many of you already understand the framework surrounding this recommendation, but a little bit of background. California's main water quality law requires the adoption of plans to achieve desired water quality conditions in California's river systems. There are also federal requirements that go to this. These plans are called water quality control plans. And one function of a water quality control plan is to adopt flow objectives to, in part, protect fish populations. Now, the State Water Board has previously adopted 2 water quality control plans for the Delta that include flow objectives for fish in 1978 and 1995. The board's taken other actions, but we're focused here on those flow objectives for fish. Now, state and federal law requires regular review and updates of these plans. And for various reasons, both understandable and challenging, the State Board has not comprehensively revised these plans' fish protections since 1995. Now, the Delta Water Quality Control Plan in particular is at the center of California's state water policy. And our group was all agreed that the lack of a plan has had an outsized negative influence on California's water resources management. The board itself recognizes the need to revise the Delta Plan. It adopted a framework for doing so in 2018. Now, that framework established 2 phases for updates, with phase 1 focusing on the lower San Joaquin River and tributaries in the South Delta, and phase 2 focusing on the Sacramento River and tributaries and Delta outflow, among other things. Now, in December of 2018, the board adopted a phase 1 decision that revises the fishery flow objectives for the San Joaquin River and tributaries. Designed as comprehensive in-stream flow standards, these objectives require a specified percentage of unimpaired flow to be left in stream to support fish populations. That's how they work. So the phase 1 decisions, as many people know, allowed and encouraged stakeholders to collaborate to determine how to implement these in-stream flow requirements on specific stream systems, bringing their local expertise and management expertise to bear, provided that the agreements fulfilled the legal obligations and were scientifically defensible. This is called the voluntary agreement process, or VAs, and the Newsom administration engaged in the phase 1 VA process for almost 3 years until last October, when, as many of you know, it concluded that the discussions had not produced defensible objectives and directed the State Water Board to implement the phase 1 decision. And last December, the State Board staff proposed that the board seek to complete the phase 1 implementation by fall of 2023. So our group's view, taking into account all of these facts, was that in light of the fish crisis in California and the state's clear authority to address that crisis, the failure to get revised fishery flow objectives across the finish line for whatever reasons is an unacceptable public policy failure. And to address this issue, the group recommended that by a date certain, by which the State Board must implement phase 1, our recommendation, sorry, I tripped over my words there, was to require by a date certain that the State Board implement phase 1, and by a date certain to adopt phase 2 updates. So specifically, the recommendation is that the State Water Board adopt a phase 2 update by December 31st, 2023. This would address the Sacramento River and Delta outflow, and that the State Board implement the phase 1 update adopted in 2018 by December 31st, 2023, addressing the San Joaquin River tributaries, South Delta, and other resources. So these recommendations integrate the state board staff's own timing estimates, which set that date they were aiming at for the end of 2023. Now, this is, of course, ambitious, but the group's sense was that the fish don't have time to wait longer for further delays, and that these recommendations do not focus on the content of the water quality control plan, but only that the water quality control plan be adopted and implemented. The content of the plan is left to the state water board's expert discretion based on the science available to it. So in addition to these deadlines, the group recommended, recognizing the long delay and all of those factors that led to that long delay, the group also recommended a mechanism to incentivize administrative action and also incentivize the engagement of stakeholders on that faster timeline that we think is necessary. And the mechanism that we propose would preclude the board from approving any new water rights or extending time on water rights where the result would be new or increased diversions to surface storage from the Sacramento-San Joaquin River watershed. This seems appropriate given that these fish flow objectives would be necessary to protect fish populations in light of any such approvals. So with that summary of the Delta Water Quality Control Plan recommendation, I'll turn to the second and last recommendation for fisheries, which focuses on the issue of temperature and how they affect fish. Specifically, the group recommended that the state amend Section 5937 of the State Fish and Game Code to require consideration of temperature as well as flow. So again, a little background for those of you who aren't familiar with Section 5937. Now, we went into this recommendation knowing that one of the substantial drivers in the decline of California's fish populations is temperature. That's been scientifically demonstrated. One example of this impact is temperature's impacts on the Sacramento River winter run Chinook salmon. The winter run Chinook are at near-term risk of extinction, in part due to high temperatures. In fact, during the recent drought, 2014-2015, we had a massive loss of the year class of wild winter run Chinook salmon. And the state is predicting future high temperatures and in turn devastating, in some case, potentially complete loss of California's native salmon populations. So California law currently requires that reservoirs release water to protect downstream fish populations. This is Section 5937 of the Fish and Game Code. It actually originated early in the 20th century with a provision in the California Penal Code. This section requires dam owners to release sufficient water, that's a legal term, to keep downstream fish in good condition, also a legal term. We know, in light of what we've talked about already, that science establishes that without a doubt that keeping fish alive, much less in good condition, requires not only a specific volume of water, but also that water of an acceptable temperature. And so in recognition of this science and in recognition of the status of these fish populations, the group unanimously recommended that Section 5937 be amended to require that dams release, our reservoirs release, water of sufficient temperature as well as sufficient flow volumes. So with that summary of our fishery recommendations, I will turn the mic back to my colleagues and look forward to our Q&A.
Thank you very much, Jennifer and Clifford. As you can tell, these recommendations, virtually all of them will require legislative action, either through a budget process or through the enactment of bills. And we're blessed today to have Dennis O'Connor here because any of these are going to go across his desk. And he is going to be the one who is going to be working with his committee members to interpret, to explain, to improve these ideas. So Dennis, we're looking forward to your comments.
Thank you, Jonas. So with that, I need to start off with a bit of a disclaimer. The views I'm about to express are my own and not necessarily of my chair, Senator Stern, or any of the members of the committee, past, present, or future. Also, while I may see positive things about some of these proposals, be assured that should any of these proposals end up being bills before our committee, my analysis will be critical, thorough, and accurately reflect the perspectives of both proponents and opponents. And then third, the fact that in anticipation of the release of these recommendations, I've submitted language to turn many of these proposals into legislative bills. That should not be construed to be an endorsement of the proposals by me or our committees of the proposals. We submit lots of language as a courtesy in anticipation that members may want to have a bill on some subject or another, and this fits that category. So with that, I want to start off by making it clear that passing bills regarding water and water rights is understandably difficult. Water rights are property rights, and people are understandably resistive of any proposal that appears to them to potentially impair that right. This is especially true as water supplies become more and more scarce. Consequently, to pass a bill on this sorts of stuff, it requires an author who is reasonably knowledgeable in water rights, has credibility with all the various different water interest groups, and is adept at moving bills through the legislative process. And even then, it may take 2 or 3 runs at a bill before they're successful. As an example, Senator Pavley twice tried to pass a bill, a policy bill to make well logs public, which are just a technical report on the sort of the as-built of a well. And it proved so challenging that ultimately she resorted to getting it into a budget trailer bill to get it passed. And then speaking of Senator Pavley, she did try to get a couple of these proposals included in the 2009 water package, but was ultimately unsuccessful. And I'll point those out as I go quickly through these various recommendations. Now, the one recommendation that Cliff and Jennifer didn't really talk about is their recommendation that the State Water Board and the Department of Fish and Wildlife need to be provided sufficient funding to carrying out their existing and new responsibilities. This is really, really important. Traditionally, water rights activities have been funded through fees on water rights holders, with the presumption that enforcement of those laws benefited the water rights holders the most. Water rights holders understandably balk when asked to fund things that they don't see as benefiting them. Such things as the Water Board's public trust responsibilities fit that category. Protection of public trust resources benefit all Californians. And one could reasonably argue that all Californians ought to pay for that through the general fund. A similar argument applies to the Department of Fish and Wildlife. Hunting and fishing fees support much of the department, and yet they too have public trust responsibilities. Over the years, the challenge has been getting general fund monies to resources issues. We get some money during periods of surplus, but as soon as we hit one of our periodic downturns, those funds are usually the first to get cut out. My final comment on this is that if we pass a law but don't fund its implementation or enforcement, it is often as if we never passed the bill in the first place. So I'm going to just sort of kick through each of the different recommendations as I go. The recommendation 2 was funding sources for NGO and tribal participation in the state board and regional proceedings. This is for the water quality side, this is something that could be done with a policy bill, as we do have existing language in the water code for the water board and the water quality control boards to fund different things for their proceedings. But that would come out of a fund that's continuously appropriated to the water board and would trigger a 2/3 vote threshold. So there may need to be some technical work on that. On expanding it to water rights processes, you know, I would think that this might be better through the budget process, and finding the funding source is going to be a challenge. The Water Rights Fund probably isn't the best source. However, as I said, getting general fund money into these sorts of things has been a real challenge. So that's going to be sort of the technical problem with that, is how are we going to fund it all? The next recommendation 3 had to do with having at least one member of the state board and the regional boards be qualified in environmental justice. I will just note that the state board does have such a member on its board, Laurel Firestone. And so I think there will be some discussion as to whether or not this is actually necessary, insofar as a governor already can and has demonstrated that they can do this. This one might be a heavier lift than one might think just by looking at it. Moving on to implementing the human right to water through the Groundwater Sustainability Agency stuff. I definitely agree this is a real concern. But again, it's not clear whether or not legislation is necessary, because we don't know exactly how DWR is going to deal with the various groundwater sustainability plans that it found to be incomplete. They did raise the issues that in a lot of these plans that they didn't see the attention to drinking water that one might have expected. But we don't know what the magic threshold is for them when the various groundwater sustainability agencies update their plans to try and comply. What is considered good enough for the department? And it's also not clear that this would address another challenge that we have with domestic wells, and that's well interference by the large agricultural wells adjacent to domestic wells. I've had a couple of conversations with the Legislative Council about this, and it's going to be technically a bit of work to get this done. You know, for example, we don't have a definition of domestic wells in SGMA. There's when we talk about, you know, not having an unreasonable financial burden. Okay, so what's the threshold of that, and who gets to decide? Questions about compensation and such, and then sort of the timing of this. The recommendation is immediately, but you know, the updates for the critically overdraft basins are in 2025, and many of those folks are currently scrambling to try and get their existing plans up to snuff. So, you know, do we have them on top of what they're doing, immediately revise their plans? Do we have this as a requirement for the 2025 update? Those are probably going to be questions that the legislature is going to want to explore. Shifting to statutory adjudication proceedings, the recommendation number 5. You know, this was tried as part of the 2009 water package, and I will say that we had in that package a water rights bill that included a number of these different things, and for one reason or another, reasons being somewhat murky, and I was in the middle of the discussions, and I'm still not exactly clear why, but at the end of the day, that bill did not make it through. So on the one hand, we have you know, pretty well vetted language on what to do. But it's not clear, one, what the politics were then that caused it to fail, and then 2, how those politics may or may not have changed over time. On the recommendation regarding improving surface water rights verification, I will note that this was also recommended in the 2009 Delta Vision Committee's implementation plan to Governor Schwarzenegger. And also, we gave similar powers to the Delta Water Master as part of that 2009 package, because the water exporters thought that the Delta guys were taking water that they weren't entitled to. And so we gave those authorities to the Delta Water Master, and come to find out that the vast majority of those asserting water rights, either pre-14 or riparian rights, in fact did have those rights, or at least were able to satisfy the Delta Water Master's concerns. Interim relief, that was also part of the Delta Vision Committee's recommendations. This one didn't make it into the final 2009 bill package. It was, let's just say that water rights holders really had a difficult time seeing the benefit to them for this. And so there may need to be a fair amount of education if this is something that somebody wants to pursue. Regarding real-time monitoring of diversions and pilot projects and such, money's going to be the issue on this one, I think. But I will say that aside from the values that Cliff talked about, I will say this may also have some value in water rights enforcement. There is this thing called Term 91, which is a standard water rights term that allows the state board to tell folks that they can't divert during periods when the surface dams, Shasta and Oroville, are releasing water for Delta water quality control purposes. And there have been occasions where there have been tests where they release water out of one dam or the other, and there's no evidence of the water ever making it to the Delta. So something like this may also be helpful in water rights enforcement, besides just getting a good handle on what's going on with the water use and the hydrology and such. The issue on setting up practices and methods for water availability analysis, it's clearly an important issue. It looks at this time to me to be a budget bill type thing as opposed to a policy bill, but it would really be helpful to have some more detail on exactly what are the characteristics of what it is that we're looking for. Are we talking about modeling? Are we talking about, what is it that we're looking for? And as I was sort of noodling over this one, this might be one of those situations where it would be a good idea to set up some sort of an expert panel or something like that to explore how one might go about doing such things. And then using that as the basis for granting the state board authority or something like that. It's an interesting idea. I'm just not exactly sure what all would constitute such a proposal. Moving to the deadlines for completion of the Sacramento San Joaquin Delta Plan update. It was 30 years ago when the old three-way process collapsed, which then led to the Delta Accord and all of the CalFed stuff and all of that stuff, which was all designed to try and get to similar sorts of things. So certainly one could argue that it's time. That's certainly a point that the legislative analyst raised just this last week in their budget analysis for the State Water Resources Control Board. You should go to their website and find that report if you're interested in this. I will also note that the history of the Delta is a history of missing critical deadlines. So I'm not sure that this would actually work, but on the other hand, I don't think anything else has worked so far. So why not give this a shot? And then finally, the Fish and Game Code, a requirement that they take into consideration temperature. It certainly makes sense from a scientific perspective. My guess is that those who own and operate dams are going to be less in love with this proposal than others. But that's why we have a legislative and deliberative process, and that's to go through such things. And with that, I think I'm right on time for a change. So there you go.
Dennis, thank you very much. I just saw in a private chat that the State Bar Association has said that all of you who have participated in this, and we have a record of it, are eligible for 3 continuing education units in California water law. As you might imagine, a year of sitting in on their deliberations was quite an education. Let me just have one observation. No one entered this with their eyes shut. The issues that Dennis has raised were known to the participants, and Dennis will carry out his responsibilities to objectively review any and all proposals. And he has noted that several of them have been put forth in prior times. One of the things this group has noted, however, is that we are not living in prior times. That what we're seeing with this drought / climate change is the imposition of incredible burdens on agencies such as the State Water Board to try and figure out how to fairly administer public trust responsibilities during these shortage times and when species are at or even maybe one past extinction. So while the group is mindful of the challenges in the history, that has not deterred them from putting forth what they think are good recommendations. With that, I'd suggest we go to the Q&A, and I have them available to me, and I will paraphrase some of these, and I will just ask whoever of the panelists wishes to address them to jump in on them. Now, some of them have already been answered. For instance, as the group considered water board funding issues, and Dennis is further enlightened us, and Jennifer and Clifford have talked about potential sources of the challenges. So I think that's dealt with. Here's a question from an anonymous attendee. Irrespective of climate change, we've seen estimates of water rights exceeding availability or being over allocated by 5 times or even 8 times. Do you have any comments on the existing over allocation?
Well, I can jump in here, Jonas. So I think when you hear statements about over allocation, it's important to understand some background about California water when evaluating those statements. There is, I am sure, some degree of over allocation, and I am not a scientist. I have not run the models. I don't know the numbers. But you have to think about a few realities. One of the realities is that in our water rights system, our water rights system, as Cliff very aptly explained, is based on a concept of seniority, where you have certain water users who have the first right to take water and other water users who are junior to them. The California Water Priority System was established in order to fulfill the command of the California Constitution, which establishes our fundamental water policy in the state. And that is to use the waters of our state to the fullest extent possible under a principle of reasonable and beneficial use. This principle was established in recognition of the fact that California is a state of extremes. It always has been. And our water principles have been structured to reflect the reality of droughts and floods in California. The California Constitution provides that we must use all of our water reasonably and beneficially for maximum beneficial use in order to support those social values, the social good that comes out of using water. So the water rights system is responsive to this. It says in high water years, more people can take water than in water short years. When we talk about overallocation, it's important to understand where that analysis is establishing its locus of attention. Is the analysis talking about those water short years, or is it talking about what we might call normal water years, or is it talking about those high water years? The water rights are established so that in high water years, the most people that can use water reasonably can take it. By virtue of the definition of their water rights, they are supposed to cut back in water short years. So that is one caveat. The other caveat is that is the reality of our physical system for using water. Water is used many times as it runs through the system. Water is diverted, it's placed back into the stream, the return flow is then used again. And I don't know the extent to which the studies that identify numbers for overallocation take into account this use of return flow, which itself is reflective of the constitutional standard. So I think that there is some overallocation, but I would also want to integrate some of these nuances in understanding the degree of overallocation.
Let me
I would share Jennifer's very careful and useful remarks. Again, I'm not certain, again, in the overallocation judgments, whether we're talking about overallocation in wet years or normal years or dry years, as Jennifer pointed out. And again, the priority system, and everyone recognizes this that holds appropriative rights. You know, if there isn't any water in the system, then if you're junior, you get cut off. All right. So the system accommodates overallocation. All right. Obviously, we don't want to add to that problem by issuing more permits and licenses in overallocated streams. So that's a policy issue that we have to consider. But in and of itself, overallocation is not something that the current system doesn't have mechanisms to address.
Well, and just one final point, not all water rights are consumptive rights. So if you have a right to store, the water is still there, it's still available. You're just changing the time period at which it is available to subsequently divert. And so depending on how whomever does the analysis does it, they could easily be including non-consumptive uses in their analysis. And so that can skew the analysis as well.
Let's move on to this question. Do you envision the Fish and Game Code section 5937 recommendation regarding temperature as being applicable to federal dams as well? And how would that work?
Oh, I guess I better take that one. I guess I better take that one. Well, we have 2 Ninth Circuit decisions, decisions from the federal court, Ninth Circuit Court of Appeal, all right, which stand for the proposition that section 5937 of the Fish and Game Code is a state law relating to the control, appropriation, use, and distribution of water. That's a technical term that is contained within Section 8 of the Federal Reclamation Act. What the Section 8 of the Federal Reclamation Act says is that the Secretary of the Interior and the adoption and management of federal reclamation projects has to comply with state law relating to the control, appropriation, use, or distribution of water. We again have 2 Ninth Circuit Court of Appeal decisions that say Section 5937 is included within state law relating to the control, appropriation, use, and distribution of water. I would say that this amendment would not alter that determination since flow and water temperature relate to the control, appropriation, use, or distribution of water. So it'd be my judgment that facially the statute would not be excluded from applying to federal projects. Now, I want to distinguish facially from as applied. The U.S. Supreme Court decision in California versus U.S. Held that state law applies to federal projects unless state law is directly inconsistent with a clear congressional directive. All right, and so the question then becomes whether the application of 5937 in any particular instance violates that principle in the U.S. 1978 U.S. Supreme Court of California versus U.S. And that would depend on the facts and circumstances of the individual project.
Okay, let's go to one that's not reliant necessarily on Supreme Court precedents. Could you please address the inherent racism of first in time, first in right? When those early rights were established, no one but white men could claim them.
I don't know, Jennifer, you want to do that? I have a couple of thoughts.
I would say, from my perspective, and obviously here, I can't speak for anybody else in the group but myself, that is something we need to be thinking about. I think that one of the issues we're faced with now is trying to look comprehensively at our systems to address that past issue. And that is the impetus behind some of our recommendations related to protecting those disadvantaged communities. I would say that in many instances, there are multiple factors that are contributing to the lack of water supply for disadvantaged communities. Water rights is one of those factors. There are other factors that have also contributed. So from the perspective of our report and the recommendations that we've made, and here I want to connect to some of the remarks that the insights that Dennis provided, which are very much appreciated. I would say I think that there is an argument on many of the recommendations, many places in which current law might address some of these problems. I think there's a good argument for those, and we talked about some of those in our group. At the same time, because of issues like past systemic racism, I think that it's important that on some of these most important values, we be clear and unambiguous and establish a standard that cannot be diminished due to the vagaries of politics or regulatory discretion. And so on those matters related that are responsive to this systemic racism, I would say that our report is focused on making those fixes, those benefits, which again, those not benefits, but fixes express, again, with the understanding there's more work to do. And Cliff, you said you had a couple of thoughts.
Well, I just say we've taken a first stab at this with regard to the section 106.5 of the Water Code and the embrace of the human rights to water. All right. I might add that while first in time, first in right is a component of the California water rights system, it is not an exclusive component. As Jennifer indicated, we have the constitutional requirement for reasonable use, all right, and which allows even senior water rights users to be subject to analysis as to whether their use is reasonable. Reasonable use by the California Supreme Court has in fact changed over time, depending on the facts and circumstances. You meld reasonable use with a greater implementation of the human rights to water, and I think you can ameliorate some of the issues that are raised here. However, I would say this is an area that requires considerable further exploration. All right, and it's something I think that fruitful conversation can be developed in the future. I don't think our proposal to further implement the human rights to water and groundwater is the last word on this, that many other things can be developed and put in play. I think this is an area for further exploration.
Agreed.
Here's another easy one. Did you consider rights of rivers or rights of wetlands?
Well, let me say I'm not exactly sure what that means. All right, we have a situation in California where water rights are granted to people who divert and use water. All right, based on two fairly old California Court of Appeal decisions, the California water rights law is not allows you to grant water rights to keep water in stream. All right, there has to be a physical capture of some sort of the water. Now, the 1978 Water Rights Review Commission recommended that water rights be modified in some aspects to allow rights for in-stream use. All right, and I want to say that is worth consideration, but was not included in our recommendations. And again, I'm just speaking personally for myself and not for the group, but to allow water rights for in-stream use when a considerable number of our streams are over appropriated already, to my personal view, doesn't really add to the problem. If you've got a watershed where there is almost no unappropriated water left, giving that right to in-stream use doesn't help in-stream use. All right, it would certainly be better to use what lawyers call the police power through either reasonable use of the public trust doctrine to ensure that existing users dedicate a portion of their use to the protection of public trust values, such as wetlands or rivers. I also think there may be constitutional reasons why this may be a better and more defensible legal strategy. But again, I'm just speaking for myself, and I understand that the alternate perspective has considerable support in many areas.
I would offer that I agree with Cliff in his identification of existing mechanisms for in-stream flow. I think the rights of rivers is an interesting area that's growing in the academic conversations. I have questions more than I have recommendations about the rights of rivers at this point. And one of those questions focuses on the important question of how do we know, who gets to speak for the rivers, and how does that voice integrate with other voices in the process? California's water necessarily has to serve multiple functions and multiple needs, many of which are critical. Drinking water supply, water for irrigation. These provide indigenous communities rely on this water. Which of these voices is prioritized in this discussion about rivers? Science certainly plays a role, but science is uncertain and contains inherent policy choices. So again, for me, I have questions about the institutional framework and the decision-making process structure for that kind of a right. I also think Cliff has an excellent point about the state of our rivers right now, the state of allocation, and the priority or seniority, if you will, regarding any right given to rivers, and that we maybe should focus on our existing mechanisms under constitutional, statutory, and public trust principles to look for water for in-stream flow.
Next question, and we'd like to keep these anonymous, so I'll just tell you the initials. They were Felicia Marcus. Oops. This person asked, well, what recommendations could you not agree on? Which ones did you leave on the cutting room floor?
Oh, what's that old line? I could answer that question, but then I'd have to shoot you. Okay. I would prefer not to disclose our internal deliberations. The group we worked with was everybody was very, very smart. I mean, I just want to say that it was been such a pleasure to work with such a group of extraordinarily smart people. And smart people will have very strong views on many issues, and they were helpful. And you want everyone in groups like that to speak as candidly as possible. So I'm just not going to go there, at least not in a public forum. Maybe over a beer someplace in a bar. All right, but that's a different matter. All right.
There you go. Everybody has an incentive to invite Cliff out for a beer now. I would echo those remarks, and just really to note that the members of our group were, and I used the word remarkable before, and I'll use it again. The range of perspectives that we represented was broad, and I thought this was appropriate in part because it represents the range of perspectives in large part that you might hear in this debate out in public, to the extent we could mirror that range. So I appreciated that and thought the conversation was good. And other than that, don't have the permission from my colleagues to say more.
And let me add, as we sat in on most of the conversations, it's my observation that there was not discord amongst the members. The report clearly states that they do not believe that this is the be-all, end-all of water rights reform needed in California. It's what they could handle. And as Dennis O'Connor has pointed out, even these 11, be it through the budget process, the regular bill process, are going to be some pretty heavy lifting. So it wasn't that there were dogfights going on. When there were differences identified, the group members worked very hard to listen to the other points of view and to find a way to reconcile those, so that, yes, indeed, all of the recommendations are unanimous, and I believe they feel good about them. Not that it's everything, but it is what is. I'm going to go to a last question, which is, where does this go from here? It's a fine report in some people's view, and with good recommendations, but they're not self-actualizing. So what is the plan for moving these forward? And I will say that these distinguished water law and policy experts did not sign on to become PCL lobbyists. And in fact, this is not a PCL report, it's their report, but they've made it clear that they do not as a group wish to assume that responsibility. But there are activities underway, some of which they are involved in, that may advance it. So I'd ask them to address those first, and then I could follow up with what PCL is thinking about doing.
Well, I'd say for my part, I've largely got to defer to others on the implementation. I am happy to continue lending, for what it's worth, some of my background knowledge to these discussions where appropriate, but on the details, I defer to folks like Dennis, who know how to get this done.
Yeah, that's kind of outside of my lane. All right. And so I'm going to kind of stick in my lane as someone who has some experience in water rights law, and I'll leave the other aspects to people who are certainly more qualified than I to work in that area.
I will note that Clifford and Jennifer, you have volunteered to provide technical information to parties. And I know Clifford, you've been doing some of that already, not an advocacy role, but an explanatory role, which is, as Dennis pointed out, very important just to have the information out there, and certainly well-researched information. By the way, also, I encourage participants to look at the CATs, because there's a lot of good information from you all on some of these issues. Andy Sawyer points out that the provisions of 5937 did not actually start in 1915. In the chat, he traces it back to the 1870s. So there's a lot of good information there. I do note that some of the members of the group, as individuals, are going to be going forth with more public statements. I believe that a couple of may be penning an opinion piece that will run shortly. And then as for PCL, we are an advocacy organization. This is not our report, but we do agree with its recommendations. So as part of our advocacy, we will be going, working with stakeholders, with legislative staff, with legislators to advance these, recognizing that along the way, no matter how carefully these group members were able to craft recommendations, some very specifically in the legislative process, there are improvements, I'll call them, amendments that seasoned legislative staff such as Dennis are going to detect and remember the something that needs further addressing. So we're going to be sticking with that and looking to work with a broad range and a diverse range of stakeholders to move as many of these forward as possible. As Dennis also pointed out, Rome wasn't built in a day, and big water legislation is frequently not passed even in 1 year or one session. So we're in it for the long haul on this, and we're going to appreciate the contributions of others as you see how these fit into your agendas. Let me ask if Jennifer, Clifford, and Dennis have any closing remarks in our remaining 3 minutes.
I would
Well, I would
offer,
just,
go ahead, Cliff.
I would just want to echo something that was earlier said. We touched on 3 important areas: water justice, water rights management, and climate change and drought, and then the fishery extinction. I'll be first to admit, I don't pretend to think that our recommendations solve all of these problems. All right, they take a stab at them. They're a first step. Okay, all right, and I would urge others to think creatively about what the 21st century brings to water resource management, given climate change and other factors, and that this be part of a conversation, not an end game. All right, because we need more deliberative thought on what our system of water allocation looks like as we look at our new challenges.
And I would echo those comments and underscore something that I'll continue. I've said before, and I'll continue to say, which is that there's going to be resistance from various sides to some of these recommendations. And I hope that the folks who are on any given side of these recommendations can come together around the understanding that we are in a time of crisis. We have a climate crisis, we have wildfire crisis, and we have droughts intensifying over time. The greatest business asset to water users is the health of our water systems. And if if we can all think in terms of supporting that asset and looking ahead to the future in a way that connects to the common good, maybe we can get some things done that we haven't done before. So I hope you think creatively and be brave.
And I guess I'll just, for my part, I'm looking forward to seeing what comes across my desk and being able to weigh in on the getting the words right, which is underappreciated aspect of what it is we do here in the committees. So.
And I wish before we leave to also thank Sofia Rafikova, PCL's Program and Operations Coordinator, who really was the one who kept the group together in terms of scheduling, logistics and whatnot. Without Sophia, these good brains would not have been able to connect. So thank you, Sophia.
And thank you, Jonas. Thank you, everybody. Great panel. I love my job. It's great to work with such wonderful, smart people. And thank you, Clifford and Jennifer, for all your work the past year or so. And thanks for joining us, Dennis. So great first session. Thanks to all the participants for being here. If you are going to log out now, make sure you fill out your feedback form for us. Recordings will take about a day to get posted up to our website. Sophia posted the link in the chat box for anyone that's interested in following up with documents and or recordings. An email will be sent out to all registrants as well with that link. And our next session will be starting at 10:45, and it is getting to carbon neutral. What is the true cost? And we have some wonderful panelists and a VIP showing up there as well. So thank you very much, and we'll see you in about 15 minutes. We're going to leave this open and keep this rolling if you want to stay on. Otherwise, you can log off and log back on at your pleasure. Thanks so much. Have a great day if you don't stick with us. Welcome for those that are joining us new this morning to our 2022 California Environmental Assembly. This is our second session of the day. Our first session was on updating California water laws. Just a little bit of housekeeping for those that didn't join us this morning. There's going to be a question and answer period, and there's a Q&A box and a chat box. We ask that if you have specific questions for the panelist or the moderator, that you put it in the Q&A box. And you're welcome to type and chat and converse via the chat box. So just that differentiation between those two little dialogue boxes there. The sessions are being recorded. Links to these sessions will be available post the session. Takes about a day or so for us to get them up online. All the information that you will see during the sessions, any documents, any slide presentations, anything that any of the panelists will be doing will be posted as well. We also will be uploading the Q&A and the chat box. We got a couple comments this morning that people were having a hard time saving from the chat environment. So we will be posting all of that as well. There will be a feedback form that Zoom will ask you to fill out once you leave the session. We really ask, just take a few moments. It's very quick and easy. We ask that you fill that out if you can. That feedback is extremely useful for us. We learned a lot last year, being our first virtual assembly that we have hosted. We've done this for decades, but last year was our first virtual. So we got a lot of great feedback from last year that helped us this year. So please fill that out if you can. And if you have any questions, please contact events@pcl.org. Or if you would like to support the assembly and the work in general that PCL does, please consider donating at pcl.org/donate. I want to give a big thanks to all of our sponsors. We can't do this without you, but we want to give a big thank you to our gold and silver sponsors, Ralph Perry, Chatton Brown, Carsons and Minter, Sage Sweetwood, Vistra, Shoot Mahali and Weinberg, and LADWP. So thank you to all of our sponsors. It is extremely necessary to have sponsors to make this work. So let's go ahead and jump into our second session here for the day, climate change mitigation and protecting disadvantaged communities. I am very pleased to introduce our moderator, Doug Karstens. He's a PCL board member and managing partner of Tatton Brown, Karstens and Mentier. And I'm going to embarrass Doug a little bit. He has the honor of being liked by his colleagues and nominated to be our incoming new president. So that is coming up in our next board meeting. So congratulations and my condolences for being my new boss, Doug. Thanks very much.
Well, thanks for telling me, everybody. When you're not in the room, they always give you the job, right? So thank you, Howard, for that introduction. And thank you, everybody, for coming this morning. I mean, this is a thrill to be here, electronically speaking. I see and want to say good morning to Veronica there on the screen, but on mute. And our other panelists are here as well, or coming soon. I want to set up this morning. I mean, PCL is a chance to meet old friends. You saw it in the last panel, and new ones. Hi, Eddie. Eddie on there, also showing up on the screen. Is a chance to meet old friends and new ones. And this panel called Getting to Carbon Neutral, what is the true cost? I also thought of it as, well, what is the true cost of not getting to carbon neutral? And Attorney General Bonta, welcome. I see I'd like to introduce or say a few remarks and then introduce you as well. But thank you for joining this morning. To set this up, I want to take us just 4 minutes to ask you to think back to about a year ago in January, when workers in the nation's capital and elected officials were cleaning up the mess from the January 6th attack on the Capitol. And President Biden was getting sworn in. January 20th was Inauguration Day. It was a new day in this country. It was a bright morning. It was sunny. It was crisp. Optimism and hope filled the air, vibrating with the poetry of Amanda Gorman. And I like to think of it as one step back, a big step back, being followed by 2 steps forward. You've heard the expression, Bruce Springsteen's song, One Step Up and 2 Steps Back. It's a sadder version of it. And same with Olivia Rodrigo's last year, and hers was 3 steps back. But we as a country took one big giant step back, and especially for environmental protections and protection of vulnerable communities. But now we're going to take 2 or 3 or more steps forward. A year ago, President Biden called on a senator from California to step up and be his vice president, and that was a historic choice. And an attorney general from California stepped up to be the Secretary of Health and Human Services, another historic choice. And that meant California needed an attorney general, and a good one for the ages, a historic choice, who's here with us today, Rob Bonta, in just a moment. And the president named and appointed a regional administrator for Region 9 of EPA recently, just last December, named Martha Guzman, another historic choice, who planned to be here today, but unfortunately those plans changed. They had to change, and we hope she'll be with us in a future PCL assembly session. And at the regional level, a former chair of EPA's NEJAC, which is the National Environmental Justice Advisory Council, a former chair came to be the head of environmental justice work at the Bay Area AQMD, historic in her own right. That's Veronica Eady, who we saw just a moment ago, and will be back. And activists like Eddie On with Brightline Defense are stepping up to fight for their communities now more than ever. And more on those introductions later. So people who are reflective of America's great and bountiful diversity are stepping up and being called upon to put their hands to the levers of power and use them to lift people up. And we're going to talk about climate change today and how to meet one of the greatest, if not the greatest, challenge of our times, which is climate change. And the COVID pandemic is certainly a current and a challenge we're all dealing with. Viewing this on Zoom is evidence of that. But climate change is going to be with us as a human race for much longer, for years to come, probably more seriously impacting human health for decades than COVID. There's no vaccine shot for climate change. And so how do we deal with climate change, the crisis, and ensure the weakest and most vulnerable of our brothers and sisters are protected and benefited, as well as the strongest and most privileged among us? The arc of the moral universe and of history bends toward justice, but it's not going to bend itself. It takes work by all of us at every level, the federal, state, local levels. And so to kick off the discussion, and certainly I would love to hear the comments this morning, but also the answers to questions if people will put questions in the question and answer box. But to kick off the discussion is Attorney General Bonta. Attorney General Bonta, less than a year ago, April 23rd, 2021, was sworn in as the 34th Attorney General of the state of California. Born in Quezon City in the Philippines, where I have an aunt in Quezon City in the Philippines. He's the first person of Filipino descent and the second Asian American to occupy the Attorney General position. Attorney General Bonta has led statewide fights for racial, economic, and environmental justice and worked to further the rights of immigrant families, renters, and working Californians. Attorney General Bonta, welcome. I really appreciate you coming this morning, and please take the stage. We'd all be clapping if you could only hear us, but please let me turn it over to you.
Well, good morning, everyone, and thank you for that very kind introduction, Doug. I really appreciate the framing and very honored to be here. It's just super wonderful to join you and PCL. And thank you for your opening comments, Doug, particularly whenever I hear the words of Dr. King. Those always resonate with me. And you're right in your words, the arc of the moral universe, it bends towards justice. And we have to also recognize that it's not going to bend itself. It's not preordained or predestined. It takes all of us at every level to fight injustice, to lean in, to create that bending and create that future, that shared future and that common future that we all want for ourselves and for our children and for our grandchildren. And that's how I view the climate crisis, that it is the injustice of our generation. It is the injustice of generations next, and it demands all of us to step up and be active and be involved and to be in the game, not on the sidelines as spectators. And before I speak about how we're stepping up for our planet and communities at the California Department of Justice, I want to simply thank all the folks attending this environmental assembly. California's environmental leadership, we know, and we're very proud of this fact, is unmatched. And PCL and its members, everyone watching today, everyone participating, you're a large reason why. You represent that California spirit of being doers and visionaries and on the front lines and forward thinking, safeguarding our land, our air, our waters, and the health of communities has been your North Star since the 1960s, and it's our North Star at the DOJ too. Our state proves that climate action, it's a win-win. We're the 5th largest economy in the world. It's undisputed. It's a fact that is irrefutable, and our commitment to the planet and communities hasn't stopped us. In fact, it's enabled our economic growth. Here in California, we've been leading this work for generations. It was Californians feeling the toxic effects of smog in Los Angeles who enacted the nation's first air pollution control program over 70 years ago. It was Californians seeing the environmental destruction offshore drilling caused in Santa Barbara in 1969 who successfully urged the state to stop approving new drilling leases in our waters over 50 years ago. It was Californians concerned about global warming in the early 2000s who passed the historic nation-leading AB 32 to enact a comprehensive and nation-leading program to sharply reduce greenhouse gas emissions. And while we are certainly on the right path, I hope the next generation can say, looking back at us, that it was Californians tired of the droughts, the wildfires, and thick blankets of smoke, tired of their children living next to polluted corridors, who demanded that their elected leaders and leaders across the nation and the globe took the decisive actions that stopped the climate crisis for good. We're on that path, but we got serious work left. And the evidence is all around us. In 2022, there is not a wildfire season anymore. It is year round. This week, in the dead of winter, there was an active wildfire burning blocks away from the literal edge of the ocean. In 2022, more children will be diagnosed with asthma as they breathe in dirty air while living next to polluted corridors. In 2022, farm workers will die while laboring outside to harvest our food during heat waves. We all feel the impacts of the climate crisis, but it's our low-income communities and communities of color who are already feeling the worst impact now. Last fall, I spent a day in a town in the San Joaquin Valley, Poplar, California. It's primarily an impoverished agricultural community with a large elderly Filipino and Latino population. And in Poplar, Filipino grandmothers in their 70s harvest grapes as they breathe thick clouds of pesticides and dust in harsh conditions and heavy heat. When a heat wave comes through, they labor. Others turn on their air condition. When the drought dries up their wells, they lose access to water, while others conveniently turn on their faucets. When a flash flood destroys homes, their trailers are gone. Others file an insurance claim. And whether it's a rural community like Poplar or an urban community like East Los Angeles, communities living at the intersection of poverty and pollution are feeling the impact of the climate crisis today. And this is how I view climate change as Attorney General. I come to this fight with a deeply held commitment to environmental justice. That's why under my watch at the DOJ, we have expanded our Bureau of Environmental Justice to bring more resources to our team fighting for our most vulnerable communities impacted by climate change and environmental pollution. That's why we are fighting to undo some of the Trump administration's most outrageous environmental attacks and fossil fuel giveaways. We are filing lawsuits against big polluters to hold them accountable for harming the health of our communities, especially those that live at the intersection of poverty and pollution. We are calling on Congress to pass an array of critical environmental legislation and climate change related legislation. And we are fighting in court to ensure development in our towns and cities does not exacerbate wildfire risk and in doing so endanger our communities. We are ensuring air districts comply with state air monitoring requirements for refineries. We are working to ensure municipalities are in compliance with our laws requiring local governments to address environmental justice in their land use planning, and so much more. In these efforts, I'm guided by my parents who guide me in all of my efforts. They were and still are my biggest supporters, my biggest inspirations, and social justice activists to the core. With me in tow, following missionary work in the Philippines, they moved to California's Central Valley when I was just a young boy to organize farm workers for better wages and working conditions. They fought alongside labor giants, iconic figures that we so rightfully admire, like Dolores Huerta, Cesar Chavez, and Philip Vera Cruz. I have faint memories from those days. I was so young when I was living outside of Bakersfield in a trailer with my family, but I remember people from all walks of life uniting in common cause. It didn't matter if your dad was Cesar Chavez or if your mom was a migrant worker. We were all there to change history, to advance justice, to bend that arc of history towards a more just world. And just as they did in the 1970s, now is our moment to change the course of history, to tackle the gravest injustice of our generation, a crisis that threatens literally all of humanity. And we're going to keep doing our part at the DOJ. We'll do it in partnership with the Planning and Conservation League, with all of you, with the organizations represented at this conference and others, and leaders like all of you, because it will take all of us in partnership, in collaboration, teaming up, focused on a common goal to be successful. So let me just say it to end, thank you for this honor and this opportunity to speak with you. I'm looking forward to our conversation. Appreciate all you do every day, all you have already done, and all I know that you will do in the future to take on this crisis head on and make sure that we're successful for our generation and future generations. Thank you.
And thank you. I mean, where to start? There's so much there. Could anybody ever imagine you would be the Attorney General of California when you were there? Thank you for those remarks. I mean, you mentioned the children living along the polluted corridors, families on these corridors, warehouses being placed in environmental justice communities in disproportionately, and you've taken an active role to combat that. Can you share why this work is a priority for DOJ, and if you're able, what criteria you use for when you're taking action?
So broadly speaking, I'll make a few remarks in response to that question. We all often talk about climate change, climate justice. We often talk about data and statistics and the global warming and how many Celsius we can absorb and increase before it leads to catastrophic change. There's many a critical scientific study on this issue showing that climate change is real and what we need to bend the arc and to move the needle, and that's all important. And climate change, to me, it's not about temperature changes and or polar bears exclusively, although it is about that. To me, it's about people. It's always about people, and people like those children who are full of potential and dreams, and are being hurt because of nothing that they've done. A world that they've inherited, and are being forced to drink dirty water or breathe unhealthy air. And we need to do better for them. And so I think about people and children and seniors and families and everyday folks and how they're hurt, and how the actions that are being taken by some create major health and life consequences and outcomes for neighborhoods. And I always think about the most vulnerable. I see my role as being the people's attorney, to fight for everyday people, especially the most vulnerable, the voiceless, the hurt, harmed, and abused, those who've been forgotten or cast over, who voices aren't being heard, and to be their voice. That is my job, to stand with them, to see them, to value them, to fight for them, and to make sure that they're not being hurt, that someone is not abusing their power, and that they're treated fairly. So that equity lens is so important to me, and to always look through it, to see the most vulnerable, to say, you're being hurt first and worst, and you're deserving of the support and the protection of the vast resources of the California Department of Justice, who sees you and will fight for you. And that takes a lot of forms, whether it be disadvantaged communities that are being hurt by warehouses that are being built in the Inland Empire, or those who are suffering from big polluters, those who are being hurt by the inappropriate waste disposal practices of Walmart, something that we announced recently. The list goes on and on. It takes a lot of different forms, but that fundamental view of protecting people and protecting our most vulnerable always animates and defines the decisions that we make.
Well, and speaking of abuses of power and outrageous attacks, as we were last year, you may know the PCL Assembly last year heard from Matt Rodriguez, who was acting Attorney General, and all the efforts to push back against the federal government at that time. And that leads me to ask, now that there's a different government and different people in power at various levels, what changes would you want to see, both from the federal government, from the laws, from the administration, and at the state level? It's a big question, sorry, but there's just so much to push back against.
Well, every moment for leadership is defined by the environment that we're in. And from 2016 to 2020, we were in a very different environment in California vis-a-vis our federal administration. And thankfully that has changed now. But I believe that during that time, Attorney General Becerra was the leader that we needed, and did an incredible job in so many areas, certainly in the environmental justice and climate change space, fighting for California, for California's people, for our values, for our natural resources. And as you know, famously sued the Trump administration over 100 times. The majority of those cases were environmental cases that fought against the rollbacks and the removals of protections and for greater support and protection of our natural resources and our environment. And so, with a federal administration now, the Biden administration, that shares values with California, we hope that there will be changes in a number of the policies, practices, rules, initiatives of the federal government, and that always, I believe that California is in this issue, and in this space and others, is a national leader, an international leader, a global leader, and it has led to that phrase in politics: as California goes, so goes the nation. So I'd like to see a federal administration that more and more becomes more aligned in terms of the policies, the level of urgency, the levels of protection that we have in California, and that those are more adopted at the federal level. And we're seeing that happen. We're providing input on different rules during the rulemaking process. We're providing partnership on a number of past cases to resolve them in a favorable way for our environment and consistent with California's values. So I hope that trend will continue. And it can't happen fast enough. We all know that when it comes to climate change, the scope and scale of the challenge is so vast that our policies and our actions in response must match that scope and scale. So we need to be more urgent. We need to be more aggressive. We need to push as hard as we can, as soon as we can.
And thank you. I mean, I see somebody mentioned there's no acceptable level of poverty in communities that you've talked about, the frontline communities, the ones that feel climate change first and worse. Helping those communities help us all, but it helps those communities. And that's how we need to all help each other. I completely get that. You mentioned your Bureau of Environmental Justice within DOJ. I wonder if I might ask if you could address how you're using the California Environmental Quality Act, or CEQA, or other environmental statutes to create better living conditions in disadvantaged communities, how to lift them up using the laws.
Absolutely. And I just want to comment on that prior point made around our frontline communities that are hurt first and worst. I really believe that our society, California, should be judged on how we treat our most vulnerable, whoever that may be, our children or our seniors or our sick or our poor. And we always need to be thinking about them first, and certainly uplifting those communities uplifts all of us. It uplifts those communities as well, but it also is a testament to who we are and what we stand for and the values that we share. That should be intertwined with all of our work. And the Environmental Justice Bureau is a tool to pursue those values of helping our most vulnerable communities. It's not the Environmental Bureau. It's not the Bureau to address climate change. It's the Environmental Justice Bureau, and that word justice is full of meaning. Our Environmental Justice Bureau has 12 attorneys. They're solely focused on fighting environmental justices throughout the state, giving a voice to those frontline communities that we were talking about, who are all too often under-resourced and overburdened. And in addition to the Public Rights Division within my office houses 3 sections: the Natural Resources section, Land Law and Conservation section, and Environment section, that include more than 150 professionals who enforce state and federal environmental laws. Certainly CEQA, its federal analog, NEPA, as well. Those are very powerful tools that we use often, whether it be in comment letters or in litigation or anything in between, to make sure that the values that they enshrine in the law are being followed and being implemented and being used. And we've been doing a lot of work in the warehouse space in the Inland Empire as the logistics sector and the goods movement part of our economy are growing rapidly. We want to make sure that we do both things at once, that we provide economic stimulus, support our growing economy, but also do it in a way that's responsible, that is consistent with our environmental laws, and that is consistent with environmental justice, making sure disadvantaged communities are not being heard and required to suffer the burden of those many more diesel truck trips that are part of that logistics sector. So we've been very involved in that space, again, from letters to litigation. We've also created a manual in our office regarding responsible environmental justice and environmentally responsible building of warehouses, so that folks have a good sense of where we will be on any given project and can sort of head it off at the pass if they want to honor the guidelines that we've provided. We've also been involved when it comes to building in wildfire-prone areas. Again, not seen as mutually exclusive, but making sure that CEQA is being appropriately adhered to, and that the real threats of wildfires as well as greenhouse gas emission increases are addressed in the projects. And we believe that the projects, if built responsibly, if built with real cognition to the challenges of today of wildfires, and to address our climate change needs, that if they're built right, then they can be built. We're not saying no, we're just saying they need to be done in a certain way. And so we're going to continue to be very active in those two spaces and many others.
Well, thank you. And before asking if there's any closing remarks, I'd like to, especially thank you for the broad view of justice. We heard on the prior panel here at PCL about environmental justice in water. In a future panel, we'll hear and talk about housing justice and environmental justice in housing issues. And I forgot, full disclosure, I did work for the Attorney General's land use section in law school for 3 months, but I didn't want to omit mention of that. So there's such a lot to the Department of Justice. Would you like to make any kind of closing remark or retrospective? Because I really appreciate your time this morning, and I know you've got to, can't be with us all morning. So please, if there's anything else you'd like to leave us with as thoughts.
Yeah, absolutely. The Department of Justice is just an incredible office that has been that's full of talent. I'm so proud of my staff at all levels who fight every day for the people of California and for our values, and certainly when it comes to addressing climate change and environmental justice, fighting on the front lines. Our goal always is to be a leader, certainly in the state, but also nationally and internationally. And we lead with our values and our hearts. We're a mission-driven organization. A lot of the incredible attorneys and staff in my office could be working in other places, but they're working for the Department of Justice because of what we stand for, who we are, who we care about, and who we fight for. And our climate change and the lens of environmental justice touches on so many issues, as you rightfully point out, whether it be clean air or clean water or housing. It's a broad area where a lot of work needs to be done. So we're going to continue to be active in this space. And if there are areas where you think the Department of Justice can take a greater leadership role, can lean in harder, can do more, and you want to share your thoughts with us or partner with us, we are totally committed to a collaborative approach to how we do our work. We're proud of what we're doing, but we don't necessarily think we're doing everything that's possible or everything that's optimal. And we're always looking to be the best servants that we can be to the state of California and the people of the state. So please be active partners with us. My final closing thought will be, I've been asked many times as Attorney General, one, is this something that you imagined you would ever be? And the sort of very short and simple answer to that is absolutely not. As a child, someone born in the Philippines who was brought here by my parents as an infant and raised in public schools in California and dreamed about serving like my parents did, I never could imagine. And now that I'm here in this role, I've also been asked what keeps me up at night. And the only thing that keeps me up at night is the question I ask myself every day, which is, am I doing enough? Am I fighting hard enough? Am I being there for all the people that need our incredible Department of Justice, the Attorney General's office, and all that we stand for and all the resources that we have? Are we there to fight for them in the way that we should? And so if you have ideas about how we can be the fighters that we want to be, move the needle and make change the way we hope for, and it's part of our vision, please share it with us. But let me just end where I began, with a big thank you to all of you. Thank you for what you do every day, what you're doing in the future, what we will do together. We have big challenges ahead, but I know we can overcome them if we continue to fight hard and fight together. Thank you.
Thank you, Attorney General Bonta, and so glad you're there where you are. Again, we'd be clapping applause. There's over 100 participants. You just can't see them, but we certainly appreciate your being here and being with us this morning. I'd like to thank you, and we'll turn to frontline communities and people working with them in the next portion of this panel. But really appreciate your great works and your being with us this morning. Thank you.
Thank you, Doug. Thank you all.
Thank you, by Attorney General Bonta. Well, I would like to turn to both of our next panelists, both Veronica Eady and Eddie Ahn, who are working on issues of climate change within disadvantaged community and addressing the impacts that they are feeling. I'd like to introduce both Veronica and Eady, or Eddie, I'm sorry, Veronica Eady and Eddie, and then take questions and answers after both are able to give their presentations. So this morning, first to introduce Veronica. Veronica is the Senior Deputy Executive Officer of Policy and Equity and is the primary internal and external contact for the Bay Area Air Quality Management District on environmental justice issues, and will be providing leadership of the district's community engagement, diversity, equity, and inclusion program and policy work. Now, Veronica, there you are on the screen. Hello. You previously served as the Assistant Executive Officer for Environmental Justice at the California Air Resources Board, or CARB, and there you oversaw their environmental justice activities. And you're the former chair of the Environmental Protection Agency's Federal Advisory Council on Environmental Justice, or NEJAC. And you're highly regarded for your work protecting vulnerable communities and ensuring voices are heard in the halls of power. Veronica, I don't want to surprise you, but you did a conference in September 2021, moving from redlining to revitalization. I highly commend to everybody. It's on YouTube. We might come back to that. But let me introduce Eddie Ahn as well, and then come back to you for your remarks and presentation. We're honored this morning also to have Eddie Ahn. Eddie is an executive director with the nonprofit Bright Line Defense and has been engaged in policy and legal advocacy since 2009. He's worked on civil justice and environmental issues in the Assembly Judiciary Committee in Sacramento, and assisted multiple municipalities in Delaware, Maryland, New Jersey, New York, with workforce development, expertise, and analysis of federal constitutional law. And I'm going to say you, because I could say he, but third person, you're right here on the screen. So you were appointed to the San Francisco Commission on the Environment, San Francisco Bay Conservation and Development Commission, or BCDC, and to the Metropolitan Transportation Commission. And you currently serve on the board of the Asian Pacific Environmental Network, or APEN, and Mission Housing Development Corporation, obviously very involved in many different places and ways. And you've been fighting on the side of communities facing pollution issues for years. So Eddie, again, I'd like to turn to Veronica first, but then back to you, and then to question and answers if people will be putting those in the question and answer box. But thank you for being with us this morning, both Eddie and Veronica. Veronica, perhaps you could take it away, please.
Great. Is it okay if I share my screen?
Yes, please. Thank
Okay,
you.
I just have a few slides that I want to take us through to frame my thoughts. Here we go. So can you, I can't see the screen, so am I in presentation mode?
We can see the screen. Let me see how best to make sure.
Yeah.
And this may be Sophia and Howard are behind the scenes working.
Yeah, Veronica.
furiously
Veronica, it looks great. You're in presentation mode.
Oh, okay, good. Wonderful. Thank you for having me. I am Veronica Eady, really delighted to be here, Deputy Executive Officer at the Bay Area Air Quality Management District over policy and equity. So besides the many things that Doug said that I'm in charge of, diversity, equity, inclusion, environmental justice, community engagement. I am also within my portfolio have our rules division. So all of the rules that we're developing and publishing. I also have the planning and climate division. I have meteorology and measurement. So I have all of the people who are doing air monitoring. And then finally, I have the assessment, inventory, and modeling division. And they're the ones who are responsible for maintaining our emissions inventory, exposure modeling, and preparation of our state implementation plans. And I've been there for about over a year, or over a year and a half. So I'm going to talk a little bit about the climate crisis. I have many thoughts about it. I hope that they make sense. I'll move on to the next slide. I like to start the frame by saying, this is somebody's neighborhood. You see here this iconic photo on the left of this house in Wilmington with the refinery looming behind it. I've been to that street. I've seen the children who play on that street. You see the port of Los Angeles and Long Beach, and some trucks on Highway 710. But the other two photos, all the way to the right, you see a house with some people seated around outside. That is a community called Bayo Vista in Contra Costa County in California, and it is a public housing complex. And just on the hill in the background, you can just make out some tanks that are part of a tank farm. And so what you see on fire there is that tank farm that I believe in, I want to say 2018, caught on fire. So I was really, really happy to meet the people who live here and to try to better understand their issues. But indeed, this is somebody's neighborhood, and this is where my work starts. So I'm not going to go a lot into redlining, but I do have a redlining slide. This is the redlining map of Richmond, California. And then on the right, you see the emission modeling. And so you can just sort of, I wasn't able to overlay them, but you can just see that the emissions from the Chevron refinery in Richmond correlate with the redlining map of Richmond. So that's how we got here. Institutional, systemic racism. And it speaks to the community of Richmond. It speaks to all of those communities that you saw on the previous slide. I wanted to talk a little bit about cap and trade, but I don't necessarily want to go into cap and trade itself. I imagine that most people know, are familiar with California's cap and trade program. What is most concerning for me with cap and trade as a tool is the relationship between greenhouse gases and toxic pollutants. Greenhouse gases themselves are not toxic and they're a global pollutant, but these facilities, as you saw in the earlier photo, sit in low-income communities, people of color communities, indigenous communities, and those fossil fuel facilities themselves have an impact. You know, there are tons of trucks that come to those facilities. There are railroads that go to those facilities and ports that go to those facilities and are all generating toxic air pollutants. But there's a body of research by a number of academics, including Manuel Pastor at USC, including Rachel Morello-Frosch at UC Berkeley, including Jim Sad at Occidental College in the LA region, have spent years, and many other researchers have spent years studying the relationship between greenhouse gases and their toxic cousins that are emitted as co-pollutants. And in 2017, the state's Office of Environmental Health Hazard Assessment published a report focused on primarily concrete plants and refineries to see if they could see that correlation between greenhouse gases and co-pollutants. And so they said in their report, they said many things in the report, but they did appear to positively correlate the greenhouse gas emissions and criteria air pollutants as well as toxic air contaminants. So it indeed is a real thing. Also in 2017, in the summer of 2017, Governor Jerry Brown wanted to, as part of his departure, part of his legacy, to extend cap and trade, which was to expire in December of 2020, and extend it to 2030. So he did that through legislation, and part of that, the reason that he sought legislation and rather than kind of a policy program at CARB, which is what it had been, he wanted to enshrine it because it had been challenged by the California Chamber of Commerce and taken all the way up to the California Supreme Court. And the Chamber of Commerce position was that cap and trade is actually a tax and therefore needs to be passed by a supermajority of the legislature. That was the thinking behind Jerry Brown, was to enshrine it in law with a 2/3 vote, so that it would be, solid and defensible in court. Part of it, enshrining it in law and getting enough votes, meant making some deals. And some of those deals affected air districts, and my district in particular. In the summer of 2017, when all of the bargaining was going on over the cap and trade program and what the legislature was going to pass, we were actually trying to control greenhouse gases and CO2 in particular at some of our refineries. And, we have 5 refineries in the Bay Area. Unfortunately, with the passage of AB 398 and getting enough votes, it meant that air districts were stripped of their authority to regulate greenhouse gases. I'm sorry, I keep saying greenhouse gases. We were stripped of our authority to control carbon dioxide. We still are able to regulate other greenhouse gases. But as you can imagine, carbon dioxide is a very important greenhouse gas, particularly where the refineries are concerned. So this is language from AB 398 that says that districts shall not adopt or implement an emissions reduction rule for carbon dioxide from stationary sources, which is our purview. That is still in effect. But in order to get AB 398 passed, Governor Brown thought to address some of the issues that were raised by researchers and by a slew of environmental justice advocates who were basically protesting cap and trade and its impact on the host communities because of those co-pollutants. So the solution was Assembly Bill 617, and many people I think are familiar with Assembly Bill 617. It was a partner bill to AB 398, and it was intended to address those very localized pollutants. So turning CARB, turning the air districts towards addressing co-pollutants in the most overburdened communities in the state. Right now, there are about 15 communities across the state that have AB 617 programs, including 2 communities in the Bay Area, West Oakland and Richmond. And we're hoping that later this month, CARB will approve us to work in East Oakland. But AB 617 has its issues, including the fact that communities across the state are basically competing for limited funding and limited capacity of air districts who can, work on these programs. Recently, there have been a number of reviews of AB 617. The California Environmental Justice Alliance issued a report evaluating AB 617. Jonathan London, an academic at UC Davis, has been doing a program evaluation of AB 617 since its inception. He recently this year released another report. And actually CalMatters on Monday wrote an article on AB 617. So the image that you see in these excerpts were pulled from CalMatters, and they resonate. There were so many of them that I could have pulled, but these resonated. The struggle to achieve the law's ambitious goals have been marked by battles between residents and local air regulators, as well as the many agencies involved. Chris Chavez from Coalition for Clean Air, who's on this AB 617 steering committee for Wilmington, Long Beach, says it's a battle to get clean air regulation. It's still a battle. It's just that we have a better shot of it now than we have in a couple of years. So that's somewhat positive, but I, cannot say that the process in Wilmington, Long Beach, West Long Beach, Carson has been any easier than what we've been doing in Richmond and what we've been doing in West Oakland. And then Magali Sanchez Hall says this was a beautiful thing that was going to bring us something into our communities to protect them from cap and trade, and also try to get the community involved. That's not what I have experienced at all. So it's really troubling that you can't really fully evaluate AB 617 yet. It's a 5-year program, but the early signs are encaptured here in this Cal Matters article. So I wanted to talk a little bit about disadvantaged communities. Senate Bill 535 created disadvantaged communities where proceeds from the cap and trade program were supposed to be invested. You see here, this is Cal EnviroScreen 3.0. This was developed by the Office of Environmental Health Hazard Assessment, OEHA. They recently came out with version 4.0, but Cal EnviroScreen is used for many reasons, but it was primarily created for the dispersal of AB 617 funding and getting the funding back into communities that were hosting these facilities. So CARB invented the California and Climate Investments. That's the branding for the cap and trade proceeds. You can see on the right where some of the money has gone. I lifted this directly from CARB's website. But, some activists, some environmental justice advocates would say that cap and trade and the funding, the proceeds from cap and trade, which now are in the tens of billions since the first auction in fourth quarter of 2012. It has created this unholy alliance. I think a lot of groups are struggling, and maybe struggling is too hard of a word, but just trying to make sense of, wait a minute, we've got this program of cap and trade that is has its many issues, but let's focus on the fact that many of the facilities are in the most overburdened environmental justice communities. But there's this money, and by taking the money, people are wondering, are we endorsing cap and trade? And AB 617 is funded primarily from cap and trade funding. So again, folks are taking this money, but many people feel a little uncomfortable about it, and other groups altogether have not taken cap and trade money. So there's kind of this unholy alliance and balancing of many interests that are troubling for some environmental justice groups. I wanted to include this image of climate justice because I'm focused on thinking about how climate change, while we do have these government programs, we do have cap and trade, we do have other programs. The CARB has, we have programs that the air districts have to address greenhouse gases, but the power really belongs with the people. And I loved these quotes that talk about the disproportionate burden of the climate crisis. UN Secretary General Antonio Guterres says, and as is always the case, the poor and vulnerable are the first to suffer and the worst hit. And then we have Mary Robinson saying, climate justice insists on a shift from a discourse on greenhouse gases and melting ice caps into a civil rights movement. And I think that is what the CARB is trying to do. It's what the air districts are trying to do with AB 617, put more power into the hands of the people, share power with the people, be driven by the agenda of the communities that are most overburdened. it's an uncomfortable place for many of us. And it takes a lot of rethinking our approaches for allies in government like myself. On Monday, this letter came across my desk. It was from spearheaded by the Indigenous Environmental Network to the Department of Energy, but has had probably 200 signatories to it. And I just copied a little bit of it. But what they're saying is we are very concerned. These dirty energy subsidies from carbon capture, hydrogen, nuclear energy will perpetuate the legacy of pollution and the acts of environmental injustices brought by fossil fuel and nuclear injuries on Indigenous, Black, Brown, AAPI, and working class communities while undermining efforts to address the climate crisis. Very strong words, and it's really important for us to listen to what they're saying and to follow their lead, because these are the people who have their lived experiences. Finally, one more slide. Where do we go from here? And this is one of my favorite quotes from the author, James Baldwin. He wrote a letter to Angela Davis while she was in prison in 1970s. And the important part of this, I mean, the whole quote is important, but what he says is, for if they take you in the morning, they will be coming for us that night. He's calling for solidarity. And this was, you know, within the civil rights movement, calling for solidarity. But in the environmental justice movement, which is a civil rights movement, part of the civil rights movement, we need to be thinking about that ourselves. And I know that the activists and the community residents who are working on environmental justice, they do strive for that kind of solidarity. You know, Cesar Chavez had that kind of solidarity. In MLK and the civil rights movement of the 60s, there was that kind of solidarity. But in closing, I will say I had a thought while I was listening to Attorney General Bonta. And my thought was that the work that I do as somebody inside government is in supporting advocates and community groups. And it made me think, and I don't know, I am not a fan of racing or Formula One at all, but, you know, it made me think of those images where, you know, there's a driver and there is a huge team of people who support that driver, and they're all on the same team. They all win the race together. So I feel like the people on the front line, the residents, the advocates, they're the race car drivers. And those of us in the many branches of government, whether it's the Attorney General's office, whether it's the Federal Environmental Protection Agency, whether it's the Bay Area Air Quality Management District, we are all part of the crew that supports that driver. And that's the way that climate change should be addressed, the climate crisis, and it should be the approach from people like myself from within government. We're not in the driver's seat, we're the support. So I will stop there. I thank you very much for the time. I look forward to hearing from Eddie On, who is always inspiring, and happy to learn from him. So Doug, thank you so much.
Thank you, Veronica. There's so much there. And Ford versus Ferrari is a movie about the team of people coming together. But there's so many things I'd like to ask you and others to ask, but I would like to turn to Eddie first and hear from frontline community work. Eddie, I see you on the screen there. Would you please take it away?
Thanks, Doug. And I really enjoyed your presentation, Veronica. I'll keep mine fairly short, just to allow more time for questions. And as I talk, Sophia, if you wouldn't mind sharing the handful of slides I've prepared. The first three, just to prepare you, are just really picture driven. It gives you a sense of the nonprofit I work for, which is Brightline Defense. We're an environmental justice nonprofit based in San Francisco, particularly in South of Market neighborhood. I think one of the larger themes you'll see in our work is essentially the ability to toggle back between hyperlocal communities and serve essentially frontline communities that are disproportionately burdened by air pollution, as well as being able to try, work toward a bigger picture And in this set of photos here, you'll see, some of the work that's ongoing, our air quality monitoring program, which is actually connected to AB 617, the legislative framework that Veronica mentioned earlier. And then in the middle is an inspiration for our earlier work. Dr. Espinola Jackson was a longtime community leader, worked in Bayview Hunters Point for decades, really, before even Brightline came along to the scene. But with Espinola, we were able to work on things like the Potrero Hill Power Plant campaign, which was a fossil fuel power plant polluting on, essentially the southeast sector, Bayview Hunters Point, Potrero Hill, on polluting, communities of color that had lived there for a long time. Very standard environmental justice issue that occurs and reoccurs throughout the state. On the next slide, you'll start to see, kind of how our work has evolved over the years, which is, essentially a sprawl of community relationships and programs and policy that we engage in. On the top left corner, you'll actually see a lot of the stakeholders behind our air quality monitoring program, and they range, on the left-hand side, there's a representative, for instance, from California Air Resources Board, which administers the AB 617 program. You'll see representatives from the Air District as well. In the middle, you'll start to see a lot of the community relationships involved. The air quality monitoring program is not just a Brightline program. It is actually a co-funded partnership that Brightline administers as a nonprofit to two other nonprofits, one of them being Community Youth Center, CYC of San Francisco, and Central City SRO Collaborative. CYC works with a youth leadership cohort, and we essentially work through air quality issues with high school students, spread across San Francisco. And then also Central City SRO Collaborative works with a very specific frontline community in San Francisco known as the single room occupancy tenant population, SRO tenants. And SROs, if you don't know, are essentially a type of building that existed turn of the century. They existed in most major American cities, and San Francisco has chosen to maintain its SRO building stock to try to preserve a form of low-income to very low-income housing for residents in San Francisco. The challenge in these buildings is that oftentimes they're older, they're shared facilities, so the bathrooms, the kitchens are shared amongst, much smaller rooms. And as a result, if you imagine during, say, wildfire impacts, like severe air quality impacts, these buildings don't have modern HVAC infrastructure, which makes them, again, disproportionately burdened by the effects of climate change. It is a population that, as a result, deserves more resources. And that's why we organize things like in the bottom left-hand corner, that air filtration workshop, which is essentially like trying to work with SRO tenant leaders on building box fans and attaching air filters to them for a price tag of roughly like $30 to $40, depending how cheaply you can get the materials. So Brightline staff work with an SRO tenant leadership program of our air quality monitoring program to try to get these up and running in time for wildfire season last year. And we hope to expand this a bit more in the coming year. The thing that we do emphasize too is that, the stuff you see in that left-hand corner is really an emergency solution at the end of the day. It's not the solution. And this is where the Air District with its, access to resources can actually be very helpful, and they have been, in terms of building out their own air filtration funding program and set up partners to get out, the nicer devices, the ones that cost like $100 to $300 that would easily be outside the reach of a low-income resident of San Francisco. In the top right corner, you'll see a job training program that we run. And then in the bottom right corner, in my mind, is really some of our real value add to the policy landscape in California. So in the middle, you'll see an image around California offshore wind, which is really a new technology for California, but the idea is trying to build essentially clean energy sources at scale that can then lessen our need for fossil fuel power plants in the future, as well as create good paying jobs for particularly local union members is often a thing that we think about, how to create sustainable careers essentially in what we often tout as like the clean economy transition. In the bottom right corner too, you'll see a policy report we did specifically around SRO residents and talking about the conditions in these buildings and how they need more resources. The next slide really starts to transition into more of our clean energy work. which is really, you'll start to see as Sophia switches to the solar panels, for instance, that we can advocate for, as well as the jobs associated with it. And it's something that we think about a lot. That balance is very hard to strike in a good manner. We want to make sure that overall, as we advocate for things, that they are ultimately equitable for the communities that we care about. And that's why we're able to engage, a number of agencies, whether it's regulatory or the state legislature, or again, toggling back to local jurisdictions. When we talk about offshore wind, for instance, it's going to be cited in very specific areas of California. So being able to understand the needs of local stakeholders, the community benefits that they will like are really important. The final two slides that I'll end on are essentially around a policy term that Veronica mentioned earlier, which is the disadvantaged communities definition, which relies largely on really the CalEnviroScreen mapping tool. This here shows how the California Air Resources Board approaches the idea of a so-called frontline community or underserved community. Essentially, there's a lot of policy terms of art that float around to try to define how do we create policies centered around equity. And here you can see how it mishmashes the disadvantaged communities definition, the DAX definition established under SB 535, and a low-income community definition, established under AB 1550. And then it creates, you'll start to see how complicated it gets, like different kind of blue and orange color mapping on the side, where essentially half-mile radiuses are created around some of these mapping definitions too. And just understanding that, in the next map, we start to see how sometimes a definition can't encompass everything that we would like to in a community that we think should be served at the end of the day. And I think part of the challenge, if you just look, if we were just to focus on one of these colors, for instance, let's say just the red color, it would leave out a lot of key communities in San Francisco that should be served. And that's why sometimes like a different color or a different type of definition can get at that. These are ongoing debates that are happening both in regulatory agencies and in the legislature. Just understanding, the limitations of CalEnviroScreen is that it's a 21 factor test. So there are 21 different indicators that are blended into it. And then essentially that formula is used to assess communities against a statewide ranking system. And just acknowledging that environmental justice issues are different than, are different from, are different when comparing against communities is really important. So for instance, environmental justice issues in San Francisco will differ, dramatically from EJ issues in LA or the Central Valley. I think that's just generally important to acknowledge because so much of EJ work is hyperlocal by nature, and that's where really the accountability is. And the final slide, Sophia, if you wouldn't mind switching to that, just really shows like how mapping definitions can also change from version to version as well. And this shows particularly CalEnviroScreen 3.0, which is the version that's been used essentially for the last few years, to the draft CalEnviroScreen 4.0. And nowadays there's been a final issue to the CalEnviroScreen 4.0. And to Cal EPA's credit, they have improved upon the draft CES 4.0. I think the larger issues that Brightline has been really hoping to improve on is making sure key communities that have been historically left out of all versions of CalEnviroScreen are included. So just to name check a few, for instance, the Mission District, Chinatown, more parts of the Tenderloin. These are communities that often have a lot of socioeconomic issues, but historically may not be recognized as, typical environmental justice issues. But just considering how quickly climate change is affecting our communities and how quickly these issues are evolving, I would argue, and Brightline has argued, that we should really expand the notion of frontline communities that we are serving, with SRO populations being a perfect example of that. Who could have thought that air quality would sweep and wildfire smoke sweep the city in the way that it has over the last few years and really impact vulnerable populations like SRO tenants. And that largely drives why, just to conclude, the air quality monitoring that we do, because when we look at, for instance, the Chronicles Air Quality Tracker and how essentially air quality sensors, the low-cost sensor space that we operate in, is a lot dominated by Purple Air, which is these individual sensors that you can acquire for $200, $300. But if you think about it, only a wealthier household can really have the expendable cash to, acquire and then install such a sensor. And so when you look at, for instance, San Francisco's air quality tracker and how they even take, air quality information from mostly Purple Air sensors, the ring of sensors is essentially in wealthier neighborhoods of San Francisco. And there's a hole, quite literally in the middle of San Francisco, the Tenderloin south of Market, where sensors aren't installed because nobody can really afford these sensors, which again goes back to the notion of why these monies and this kind of funding is so important to fill that need for localized air quality monitoring that previously did not exist, and to make people aware of these issues is a large part of the work. And with that, I'll just leave it and maybe kick it back to you, Doug, to ask questions of Veronica and myself. But thanks for your time and attention.
Okay, well, thank you, Eddie. And I did have a question or two kind of at the ready, but I before going from what you were just talking about, there was a question from the audience about a publication by Joseph Sachs, Professor Joseph Sachs, about constitutional threats to slumlordism. And I haven't heard of this. I'm not sure if others have, and if you're shaking, I think I'll ask other questions than that, but that sounds like something that might be interesting out there.
Maybe I'll just,
sure, Eddie?
I don't know the particular legal analysis that's being talked about here, but I can talk about more of the historical context of SROs, because a lot of people look at SROs and they think, how could possibly, people choose to live in these buildings? And the heart of the matter is they don't choose. It's an underhoused population. I think most people would reasonably recognize that. But for a lot of SRO tenants often have, for instance, pre-existing health conditions, large socioeconomic struggles that make them unable to afford basic housing in the Bay Area. What we would, many people, looking at this call would consider basic housing. And so just understanding that, I think, is key. And oftentimes you'll hear certain people say, well, why don't we just bulldoze them? But then what happens to the communities living there? I think that's just something really basic to understand. I think SROs are particularly compact in a place like Chinatown. So it's literally like 80 square feet in which you'll cram sometimes as many as 4 people into it. It's pretty extraordinary conditions, and nobody's saying it's okay or great, to live in these SROs, but yeah, there are not a lot of options.
Okay, and thank you. I mean, housing is such a tough question and a critical issue. And it can be seen, including through the climate change impact lens. A lot of the heat islands are in urban areas. A lot of the flooding occurs in low-lying areas. So addressing housing in California and addressing climate change, they seem pretty inextricably related. So I'd like to come back to the SRO questions, or I had a different one for Veronica, though. And I don't know if Veronica, you wanted to either comment or any questions about Eddie's presentation there, but I wanted to get back to something that you had said. And this was about the inability, let's say, or prohibition for air districts addressing CO2, but that's just CO2, and there's other greenhouse gases, and there may be other ways to get at addressing CO2s that air districts might have. I wonder if I might ask any creative methods to get at greenhouse gas emission reduction with such a big hindrance in place, not being able to set limits and reduce CO2 because of that law, that I also wonder if we might have suggestions for changing. But first to the question about alternatives to CO2 regulation.
Yeah, so we are looking at methane. And I should first say that even though AB 398 was passed in 2017, it still hurts. So I am still in meetings on my job where we're talking about AB 398, and we're still talking about having lost that. You know, maybe it will change, you know. I mean, we are active in the legislature, and you know, there may be some opportunities for that to be rethought. I'm not referring to anything specific. I don't know specifically, but you know, if we and other air districts are still experiencing the pain from AB 398, there's certainly you know, the potential for things to change a little bit. But we've been focused a lot on methane, and so right now we're working on a rule that focuses on building decarbonization. And in particular, we're focused on large residential appliances. So right now we're working on a bill that, or a rule that encompasses residential appliances like furnaces and water heaters, the large appliances. So we're working right now on a rule that should come out sometime this year, limiting emissions from those types of appliances. But we're also thinking about other big, large appliances. Stoves in particular are, you know, a big source of methane, as well as particulate impacting the indoor air quality. But as you can imagine, things like stoves, the issue is somewhat fraught, particularly by restaurants that use gas appliances. And there is a huge equity issue, not only around stoves, but around, you know, what we're looking at, water heaters and furnaces. And so we really need to incorporate the impact of our regulations on low-income communities that might not be able to afford new appliances. So right now we're looking at only new construction. So just like the ordinances that have been passed in Berkeley and San Jose and other communities that have prohibited gas appliances in new construction, we're also looking at new construction. I do want to say, though, it is a really important conversation to have with EJ advocates, residents around the equity implications of those kinds of rules. And so we are. And so, you know, we're talking to consultants who work in that space. I've learned a lot from a woman named Jackie Patterson, who was the Environmental Justice and Climate Justice Director for the federal or the national NAACP. Brilliant woman who has also worked on some of these issues. So we're really also trying to lean in on experts in this area, both national experts as well as local folks who are working on these issues. They're very active on the peninsula and Silicon Valley. There are some groups that are working, you know, on this issue, and so we really need kind of that wisdom as well.
And thank you. I mean, that's kind of perfect. I wanted to turn to Eddie to ask a bit about Brightline Defense's work in the energy justice space, in both in San Francisco and across the state. I mean, can you talk a little bit about that?
Sure. So in the historical arc of our work, we've gone from stopping power plants to hopefully promoting renewable energy sources that can replace, you know, future ones from being built. So again, like the Potrero Hill Power Plant campaign was a very seminal struggle for us. But also one other big policy campaign to mention that also plays into the energy justice campaigns that we now engage in is the idea of local hiring. So trying to promote workforce development, particularly, so job training, job placement for local underemployed, unemployed communities. And local hiring ties to a lot of concepts. It can be more generally about construction of, say, like large, whether it's like anything from a stadium arena to an apartment building to whatever it may be. But in the clean energy context, what it really means is just the ability to make sure that new jobs that are springing up are not just given to, contractors that may not have any accountability again to a local community, but are actually, tied into, say, for instance, a local job training initiative run by a community-based organization or a government agency that may have partnerships, direct entry agreements with building and construction trades, unionized building and construction trades, to create those long-term pathways to what people would aspire to, which is hopefully a middle-class existence in the U.S. So with that all in mind, I think that's why offshore wind, just to jump to where we are now, is such an important campaign to work through, because it's thinking through these jobs that require, very complicated skill sets. So to even assemble an offshore wind turbine takes, a bunch of different trades working on that particular project, from the point of assembly, at the port, to even be able to ship it out. And then of course, like the infrastructure needed to support that is really important. But just understanding the types of jobs that can be created, how to shift systems, whether they're academic and nonprofit and otherwise, or government, to essentially support that kind of economy is really important, and that's ongoing policy work that we're engaged in.
Well, thank you. I mean, there's so many directions to possibly move. It's a question of addressing or putting the resources to the priorities. And I want to, you mentioned ports. I kind of want to turn back to Veronica with that, because the Port of Oakland, obviously, a huge presence there in the Bay Area. And there are sometimes, I guess, as I understand it, hamstringing from federal preemption of pollution regulations. I mean, we talk about the hamstringing by state health and safety code 38594. But what about the federal government, and how has that sort of played out in your efforts, say, around West Oakland or Richmond or the port communities?
Yeah, really good question. So in West Oakland, where we're working on one of our AB 617 communities, we work closely with the port, but I should say that our work with the port also includes the community. So we follow the leadership of our partner organization, West Oakland Environmental Indicators Project. And so the work that we do around West Oakland and the Port of Oakland is informed by that group, as well as some other organizations who are partner organizations in that work, like Environmental Defense Fund. And we actually work closely with some truckers and all sorts of, and folks from the city of Oakland on that. But federal preemption is, it is a real problem. And I should mention that we're also working in San Francisco with the Port of San Francisco. And just to kind of pivot in that direction, there are, because of some of the biggest sources of pollution in San Francisco, and in particular Bayview Hunters Point, and I'm talking about, the Hunters Point Naval Shipyard, where there's contamination, the Federal Environmental Protection Agency, the State Department of Toxic Substance Control. We actually have, in the last 6 months, I would say, started having collaborative meetings, City of San Francisco included, where we're coordinating around the work that we're doing in Bayview Hunters Point in particular. And that has been really good work, great conversations. And I have to say that the Federal Environmental Protection Agency has been really helpful, particularly since the Biden administration came in. We have regular meetings. They fly out one of their senior deputies who leads in this work. So I think that the path forward, to the extent possible, is with collaboration with federal agencies. I can't say that in West Oakland we've been as active with the federal EPA and the other federal agencies that, for example, regulate some of the sources in the port region, the trains, the ships. Our work has mainly been directly with the Port of Oakland. There hasn't been a lot of federal involvement. And I say that apart from, West Oakland Environmental Indicators Project a few years ago filed a Title VI complaint in West Oakland against the port in the city of Oakland. And in that case, there was, of course, some federal negotiation that brought it to a resolution. And in that case, it wasn't the EPA. I think it was the Federal Department of Transportation where that complaint was filed. One more thing that I will say is that, one area where air districts have been able to make a difference, where there are these kind of magnet sources like ports and like warehouses, is through something called an indirect source rule, where rather than attempting to regulate the sources that we don't have jurisdiction over, commercial hovercraft, ships, trains, the South Coast Basin, for example, has an indirect source rule recently where they can regulate the aggregate emissions from those magnet sources rather than running afoul of federal preemption and trying to regulate the trucks and other sources themselves. We do not have indirect source rule authority in the Bay Area, but we've been exploring with our legislative director and with some members of the legislature and how we might introduce some legislation to go about getting that authority.
That's really exciting. I got to tell you, I mean, I'm down here in the Los Angeles area. I'm in Hermosa Beach, and that community on your slide in Wilmington, I've been on that street too. I mean, I know exactly what you're talking about with looking out over the refineries. And being here in Los Angeles, we're right here in the South Coast, AQMD, and we're very excited about that warehouse rule and maybe seeing that in other places. If it survives, knock on wood, I think it's been challenged in court, as you would expect for such a strong and good rule. There's always a challenge. So thank you for mentioning that. I hadn't remembered that as it's so very effective. I mean, it's a landmark and people are looking to it as an example, which I think will hopefully survive. Well, let me turn back to Eddie with one other question, and then I do want to ask both your closing remarks, but I didn't want to let go without asking about the San Francisco local hiring policy that Brightline helped to craft, and the fact that it's celebrated around the country as one of the most successful. Why is it so successful? What's made it that, and how did it evolve? Do you want to maybe talk a little bit on that, Eddie?
I think part of it was an understanding of the market and then crafting, what passed as law in a way that was strategically essentially shifting the labor market to accommodate a job training system that was being put in place and being built up. So I'll give you an example. It wasn't, a lot of local hire laws are often good faith efforts, and they'll establish, a large goal, like we'll do 50% local hiring. But as you might know, good faith doesn't legally mean much. It just means, do your best effort, maybe a notice, but it's essentially very hard to take someone to court over an act of bad faith in that kind of context. And what San Francisco's local hiring policy was good at was essentially creating a mandatory floor, 20%, and then creating valves in that law so that it would increase 5% each year and then create assessment periods just to see where the market was at. And then, of course, there's a job training arm that's being built out, and there's a whole essentially ecosystem of government agencies, City Build Academy, which is, San Francisco's pre-apprenticeship program with a lot of community-based organizations helping to channel outreach into local communities to make sure there are essentially job training cohorts being produced each year to create the local qualified worker that employers could have. So in other words, it wasn't just some grand statement of law. There was actually a lot of programmatic work that also helped build up that law into success. And I think that's the ongoing challenge in our work, is that advocacy is important. And then getting, being a good champion of certain policies is really important. But also Brightline is often worried about how are things implemented? How does this thing actually look after, the big celebration and the passage happens? So a lot of it's very grinding hard work, to be frank. Like it's not terribly sexy from a larger kind of marketing standpoint, but yeah, it needs to be done. And I think that's our value add ultimately, is the ability to blend programs and policy work together to make something sustainable.
Understandable. And thank you also. I mean, that you're there doing that work. It's sort of like we talked about the local, very granular level, state, federal, everybody. I want to turn to Veronica, perhaps for the last word, if you don't mind. There's also a question kind of following up on the other, how other communities and counties might get authority to implement indirect source rules. But I wonder if you might want to address that, but also more broadly, any closing remarks for the Assembly?
Yeah, sure. Well, in terms of indirect source rules, so technically the San Joaquin Air District has something like indirect source rule authority over warehouses. There is kind of this option that the developer can pay a fee rather than, reducing the emissions. And I think that that's really been the problem with some indirect source rules, is like having that escape hatch rather than directly getting the reductions at the source. And so that's what's going on in San Joaquin. South Coast, San Joaquin, Bay Area, maybe San Diego, and Sacramento, the largest regions, and where we really need to be addressing, advocating for an indirect source rule. So that's that. In final words, I have two things. First, I do want to lift up Suma Pizzapati, who I know you all know her. I was really delighted to be able to bring her to the Air District to be our environmental justice officer. So she is using her brilliance, and she's a renowned environmental lawyer, EJ lawyer, and CEQA expert. So it's been great having her guiding that piece of the program. And then I do also want to just underscore the conversation about workers. And, Eddie, you talked about workers. And, kind of the thing that keeps me up at night is, as we attempt to address climate, as we attempt to address PM and BTEX and other chemicals that are coming out of refineries, what keeps me up at night are the workers. Because with our 5 refineries here, each refinery has hundreds of workers. We have thousands of refinery workers who show up at our meetings and testify every time we have a rule that limits emissions from refineries. So in my head, I'm thinking about how do we keep the economy healthy? How do we keep these workers in jobs? And we're looking at 2035 when, Governor Newsom wants the curtailment of selling internal combustion engine automobiles in the state. And so we need to be thinking about that as our North Star. And then what are we doing between now and 2035 to accommodate those workers, to keep them working, and to keep our economy healthy? So that's the thing that keeps me up at night. I celebrate everybody who's working in that space. So thank you. And thank you, Eddie.
And thank you, Eddie and Veronica. What a great presentation. Really appreciated it this morning. And I see, I always like to give the applause for all the participants who, can't give the applause themselves. So, consider yourselves ovated, if that's a word, with the ovation out there. Thank you, Veronica and Eddie. And Howard, I see you popping up there and want to take it away.
Yeah, thank you so much, Doug. I really appreciate it. Eddie and Veronica, thank you so much for participating. Really love the race car analogy that Veronica brought up. Sometimes I feel like I'm racing in a Pinto though, but great analogy. I wanted to thank all of our panelists, previously AG Banta. Thanks to all our sponsors for making this happen. Thanks so much for joining us today. And we have a lot more exciting panels coming up in the next 3 Thursdays. You can find that schedule at pcl.org/assembly. And you'll be receiving an email with a link to all the video recordings and the presentations that were made today. So look forward to that. When you log off, you'll see a feedback form. Please fill that out for us. It was very, very helpful. We look forward to seeing you next Thursday morning for our land use, transportation, and planning law sessions. And thank you very much, everyone, for joining us today, and have a wonderful rest of your day.